Morning, Judge.
Good morning.
We received a report from the Forensic Center via Ms. Feltis this morning, Your Honor, that is deeming him to be competent.
I had just gotten it yesterday, so I forwarded it this morning to the court and defense.
So I would stipulate to that report, Your Honor.
It would also stipulate, Your Honor, we have no additional evidence.
All right. Based upon a review of that report, the court would find that the defendant is competent to stand trial. Would specifically find that the defendant can understand the nature and objects of the proceedings against him and can rationally assist in his defense. Therefore, the defendant is competent. Do you have an order, sir?
Oh, yes.
You don't have it yet.
Not yet. You will have it shortly, Judge. Can we reset it for a PCC, please?
Yes, sir. Set a probable cause conference. What date are we on? We're 2 weeks out. 25th. Sorry. Probable cause conference September 25th, 2025, 9 a.m.
Thank you, Your Honor.
Thank you, Your Honor.
Bond will continue. Court does call the case of the people versus Shannon Roberson.
Good morning, Your Honor. Laura Roberson on behalf of the people.
Morning.
An Assistant Public Defender, Natalie Pate, with and on behalf of Mr. Roberson, who appears via Zoom from the MDOC. Sir, can you please unmute and state your name for the record?
Shannon Roberson.
Thank you, Your Honor. I did speak to the people regarding this and had submitted a stipulation to adjourn to the court. I do have an in-person meeting scheduled with Mr. Roberson for next Friday, September 19th in the afternoon at the Jackson Prison. So I would ask for an adjournment sometime after that date.
You be ready by the 25th?
I think it might be a little safer, Your Honor, for the week after. His earliest out date's the 23rd.
To be 5 days after. I have October 2nd.
October 2nd would be great, Your Honor. Thank you.
Probable cause conference will be adjourned without objection to October 2nd, 2025, 9 a.m. Bond continue.
Thank you, Your Honor. I'll see you next week, Mr. Robertson.
Oh, you say skip. You put it on there. Sorry, I don't have the 2nd because of the Tuesday, so it had to be October 9th. October 9th.
Thank you, Your Honor.
On there. I got you. Court does call the case of the people versus Cassie Colley.
Foley. Morning, Your Honor.
People.
Good morning, Assistant Public Defender Lauren Perny on behalf of Ms. Colley. Ms. Colley, state your name for the record. You did it already.
Cassie Coley.
Foley.
Your Honor, we should have a plea form in front of you with a signed advice of rights form.
All right, I have a plea form that indicates that the defendant would be pleading guilty to retail fraud second degree, the 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed. She agrees to pay restitution as ordered. That's the entire understanding of the.
That is our understanding as well, Your Honor.
All right, ma'am, if you could please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
State your name again, please.
Cassie Lynn Coley.
All right. Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of retail fraud second degree. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased at 3 times the value of the property taken. If that's greater than $2,000, that would become your maximum fine. You understand that?
Yes, Your Honor.
And they already did.
I need that one shut. Do you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form or gave permission to sign that after going through it with your attorney?
Yes, Your Honor.
Do you have any questions regarding those rights?
No, Your Honor.
You understand that you're giving up your trial rights as contained in paragraph 5, as well as all the rights that are contained on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Has anybody threatened you or coerced you?
No, Your Honor.
You're doing this voluntarily and of your own free will,
Yes, Your Honor.
and also because you believe that you're guilty of this offense?
Yes, Your Honor.
December 16, 2020, at the location of 3825 Carpenter Road in Pittsfield Township, Washtenaw County, State of Michigan. What did you do at the Meyer store that makes you think that you're guilty?
I took some items that I did not pay for, Your Honor.
All right. And you tried to walk out of the store without paying for them?
Yes, Your Honor.
Store was open to the public at the time?
Pardon me?
Was the store open to the public at the time?
Yes, Your Honor.
You didn't have anybody's permission to take that property, did you?
No, Your Honor.
And the property you took was property that was offered for sale by Meyer?
Yes, Your Honor.
All right. Is the second based upon value?
Yes,
All right. Was the aggregate amount or the total amount of the property that you took, was that in excess of $200?
Yes, Your Honor.
Ma'am, if I accept your plea, I have to advise you that if you commit misconduct as defined by the Michigan court rules between the time of my acceptance of your plea and the time of your sentencing, that the court would no longer be bound by any sentence evaluation or recommendation in the case. You understand that?
Yes, Your Honor.
You also would not be permitted to withdraw your plea. You understand that?
Yes, Your Honor.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, sir.
no, Your Honor.
And have I complied with the court rule, and would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes,
Court will accept the defendant's plea of guilty to count two. Count one is dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing will be,
September 24th at 9 a.m.
we can't do
October
it
8th.
because I need 2 weeks if she's going to be by Zoom. October 8th,
Yes.
October 8th, 2025, 9 a.m. That's before me. Found will continue.
I do have one thing, Your Honor. Miss Foley is
Go
in,
ahead, Parody.
thank you, Lenawee County.
Really? Yeah.
There were warrants issued because I believe failure to appears. They submitted her social worker from Lenawee County PD submitted warrant recalls. Your Honor set these dates but kept the warrants in place. She's has approval to go to Bear River, but these are holding her up. So there's this case, and then there's 2 misdemeanors scheduled for the 17th before Your Honor, where there's still warrants. So I'm asking that the court recall the warrant in this case, or all 3 if possible.
She will be in Lenawee the entire.
Well, she's in Lenawee, but she has a release of treatment there. So as soon as these warrants are resolved, she'll be released to Bear River from Lenawee.
In this case, it's before me. I will cancel the warrant. I'll reset her bond at a personal recognizance. $5,000 personal recognizance bond. In the other matters, I suggested you communicate with Ann, and
Okay,
we'll see what we can do on that.
thank you.
Thank you. Thank you, ma'am.
Thank you.
Court does call the case of the people versus Jennifer Lindsley.
Morning, Your Honor. Raymond Cook, the people.
Good morning, Assistant Public Defender Lauren Perny on behalf of Ms. Lindsay. Ms. Lindsay, please state your name for the record. Ms. Lindsay, you're muted. Is there a officer that can unmute your device?
That was a no.
Jennifer Lindsay.
Wow,
He's represented by Mr. Brenner, and we have Mr. View taking over for Ms. Tranter from the prosecutor's office. We are here today for a status conference. Actually, it's a hearing on the least restrictive treatment. court is in receipt of the report of Dr. McGee, which is dated August the 27th. We also have the proposed conditional release plan and the accompanying letter from the what will be ultimately the forensic monitor. In addition to the report of Dr. McGee, the court has considered all of the previous reports, the testimony, and the evidence in the exhibits in the case. Mr. View, any additional evidence on behalf of the state?
No, Your Honor.
Mr. Brenner, any additional evidence on behalf of the defendant?
No, Your Honor.
All right, based on the evidence, the court finds by clear and convincing evidence that Mr. Williams is a mentally ill person subject to hospitalization. I do think that he represents a substantial risk of physical harm to others and would benefit from treatment. I think by clear and convincing evidence that he is a mentally ill person subject to an order. We do have a report, least restrictive treatment option is placement in the community. So what's going to happen now, Mr. Williams, is we're going to transition you to what we believe will be the Doan Street housing. We think that's going to happen here in the next few days. We're going to get a conditional release plan together that provides for medication compliance. Treatment's going to be with Greater Cincinnati Behavioral Health, and we're going to move towards getting you out of the jail, back into the community. We're going to give you rules to live by so that you follow those rules, and we're going to get you, hopefully, into, after the transitional housing, something a little bit more permanent. Do you understand all of that?
Yes, sir.
All right, so I am going to set this case for submission in about 2 weeks. We think that the conditional release plan might be finalized, but not signed by everybody. We're still working through those issues. So anybody who is not in agreement with the conditional release plan can file a written objection and request a hearing. But if there is no written objection or no hearing, the conditional release plan will take place. This is going to be, Mr. Williams, a continuing order. So you're going to be under the jurisdiction of the court until we determine that you either no longer a mentally ill person subject to hospitalization or the expiration of 16 and a half years, which is the maximum prison term that you could have received if you were convicted of the most serious offense for which you were charged. Anything else we need to do? Anything that I forgot?
No, Your Honor. No, Your Honor.
All right. Ma'am, are you here from treatment?
Yes, from Greater Cincinnati Behavioral Health.
Okay. Did I forget anything?
I don't believe so.
Okay. All right. Seems like we got a decent plan together.
Yeah.
All right. That's all.
Okay, I'll call your mom. Okay, but first.
She was right on time. Your Honor, we're asking for an exam date, please.
Discovery is complete.
Yes, my knowledge.
And what facility? She's at here in Valley, so. We could do, I think. If she said here, that'd be enough time for her. Would the people have their witnesses available September 30th?
Yes, Your Honor.
Preliminary examination in person will be set for September 30th, 2025, 9 a.m. That is before Judge Washington. And we'll continue.
Thank you.
Thank you.
We'll be in touch with Ms. Lindsay.
Thank you.
Court does call. Thank you. Court calls the case People versus Terry Probst.
An Assistant Public Defender Natalie Pate on behalf of Mr. Probst, who appears via Zoom from the Monroe County Jail. Sir, can you please state your name for the court?
Terry Allen Probst.
Your Honor, I have followed the instructions on the Monroe County Jail's instructions to schedule a video visit with my client. I do have an online account created in the system. I do have the facility added. I do have my client added. It is pending approval. So I'm asking for an adjournment. If that is not approved by sometime early next week, I plan on maybe just showing up there in person and seeing what has to happen.
In what?
Asked if I can see them. They might be fine in person. I don't know.
Okay, how long, sir, how long do you, do you have a release date, I guess?
No, Your Honor, right now I'm supposed to go to court on the 15th, which is Monday.
Got it. Okay. Well, why don't I do this? Why don't I set it for the 9th, like the last one? If he gets out, then he can appear on that day. All right.
That sounds great, Your Honor. Thank you.
Probable cause conference will be set October 9th, 2025, 9 a.m. On continue.
Thank you. Thank you, Mr. Probst. I'll talk to you one way or another.
Yes,
There
ma'am.
was a bench warrant for his failure to appear.
Yes, sir.
That is,
Your Honor, I was in court. I was in here at the time of that bench warrant was issued.
Got it. What I'll do on that is I'll cancel the bench warrant and reinstate his previous bond.
thank you very much, Your Honor.
Thank you, Your Honor.
Thank you, sir. Court does call the case of the people versus Ardeen Henderson.
And for another for the people,
Brian Bowling on behalf of Ms. Henderson. Ardeen, can you state your name for the record, please?
Arlene Henderson.
Judge, just for the record, I did meet with Ms. Henderson via Zoom from the Wayne County Jail yesterday. I'm asking for an adjournment so she can continue to work with our AIM division and we can look into further possible resolution of this case. She does have a hearing in Wayne County tomorrow, Your Honor, but she did not know what would happen with that case. So, and I don't think she's going anywhere for the foreseeable future.
All right. You want the 30th or the 9th?
Let's do the 30th.
Probable cause conference, September 30th, 2025, 9 a.m. Bond continued.
Thanks, Judge.
Court does call the cases of the people versus Ronald Sims.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Sims. Mr. Sims, state your name for the record, please.
Ronald Sims.
So, Your Honor, there are 3 cases before you.
There are.
We are asking for exams in all 3. I will note for the record, because I know what question you're going to ask. 2 of the cases we do not have media discovery on. I've spoken about this with Mr. Sims at length. He would like to set them for exam, knowing that he would not get an adjournment if we do not have it by the exam date.
Is that really what you want to do, sir?
Yes, Your Honor. We'll do that. We just brought to my attention that it's something, or we can do that after, later, the next court date. Okay. Yes.
Which 2 do you not have media on?
I don't know the case numbers off the top of my head.
Okay, give me charges.
Largely from a vehicle, we have media on, the other 2 we do not.
So the B&E vehicle you do not have or do?
Okay, in the case ending in 5717, we do,
5717 you have. Oh,
yes. The other 2 we do not.
all right. Fair enough. People have their witnesses available the 25th. So 12 days out. No, let's see. Well, what's my date? 23rd. Got it. I guess I should say September 23rd, which you have people. Council. 23rd. Well, preliminary examination in person will be set for September 23rd, 2025, 9 a.m. before Judge Barr on all three matters. Bond will continue.
Ms. Thompson.
Court calls the case of the people versus Brandon Bellotti.
Ready, Your Honor.
And was that on behalf of the people, Your Honor?
Good morning, Your Honor. Joe Simon on behalf of Mr. Bellotti,
Her name,
Brandon Bellotti. Requesting a preliminary exam, Your Honor.
discovery is complete.
It is actually. It just got complete, Your Honor. It just happened.
Sounded like a shock.
Well, it's recency, Your Honor. Recent.
Would the people have their witness to the 23rd?
We'll do our best, Your Honor. Your Honor, if I could ask the court to amend and complete the police report number that's listed is incorrect.
Hang on 1 second. Preliminary examination in this matter will be set for September 23rd, 2025, 9 a.m. before Judge Fleischer.
Okay.
His bond will continue and you needed the complaint amended to,
Your Honor, the police report number is AAPD 25-37347 rather than 437.
three 7347 is what it should read.
Correct, Your Honor.
Right.
Thank you.
Bond continues. Thank you. Court does call the case people versus Stephen Grisbeck.
Assistant Public Defender Chelsea Vergils with and on behalf of Stephen Grisbeck on cases ending in 1354 and 5176.
Morning, Your Honor. Sam Bernstein on behalf of Mr. Grisbeck on 11.
What are we doing?
Stephen Grisbeck.
Your Honor, we're asking to adjourn, I believe, on all cases. We're trying to see if we can reach a global resolution. I would also ask the court to consider a release to treatment. I believe he already has that on 1354. We're asking for that as well on 5176.
I just heard bells while you were speaking. You want release to treatment. If you prepare an order, should be stipulated to send it to me. I'll sign off on it.
Okay, thank you, Your Honor.
All right. And what are we doing on yours?
Likewise, Your Honor, asking for an adjournment to try.
Okay, timing wise, you're trying to do a global resolution, but there's other cases in circuit. When are those?
No, there's no other case in circuit, Your Honor.
It's just these.
Yes, Your Honor.
He is currently serving a sentence, but a motion should be forthcoming regarding the request for release to treatment on that.
The 30th, will that work?
Yes, Your Honor.
Matters will be adjourned to September 30th. 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you, Your Honor.
Court calls case of the people versus Philip, is it DiPatrizio?
DiPatrizio, Your Honor.
DiPatrizio, that's what I said.
That's what I thought.
Okay.
Your Honor, good morning. Joe Simon on behalf of the defendant. State your name when you go.
Philip DiPatrizio.
Thank you.
And Your Honor, we're asking this matter be set for exam as well.
Cover is completed.
Yes.
People have their witnesses available the 23rd.
I'll do our best, Your Honor.
Preliminary examination in this matter will be set September 23rd, 2025, 9 a.m. That is before Judge Barr. Bond will continue.
Thank you, Your Honor.
Thank you.
You can go home. All right, we'll see.
Court does call the cases of the people versus Kevin Davis.
Morning, Your Honor. May it please the court, George Lyons on behalf of Mr. Davis in both files.
Morning, sir.
And respectfully, my client, Your Honor, after having discussed this with him and the people will be waiving his preliminary examination, Your Honor.
Yeah, waiving on both
Yes,
cases.
on both files, Your Honor. He knows and understands his right to a preliminary examination. He also understands the burden that the people have that by waiving this, the matter will be bound over the circuit court for alternate resolutions. It's affixing his signature to the waiver on both files.
Sir, is all of that correct?
Yes, sir.
And you understand that the preliminary examination which your counsel speaks about, you will not have, and this matter will be sent to circuit court for further resolution.
Yes, sir.
People also waive their right. Preliminary examination having been waived in both matters. Defendant is bound over to circuit court on both counts.
Your Honor, before the court affixes his signature to the bond, may I address or ask the court to reconsider the bond, my application for bond modification I made last time? Respectfully ask the court to consider something that includes a tether to his parents' home in Albion, Michigan, where he was raised. And
Pardon?
may the court consider a tether to his parents' home in Albion, where he's from. Mom and dad are here, Your Honor. The allegations here took place some time ago when my client was a teacher here, Your Honor, I believe 8 years ago. 6.5 years ago. Your Honor, the people's objection is that he was living in Florida. Well, he doesn't live there now, Your Honor. He was expected to be living in Michigan until this matter is resolved. He is a Michigander, Your Honor, but perhaps not a Michigan fan.
Response.
I believe his bond is appropriate as set. Nothing has changed since the last time this motion was made. He was extradited from Florida. It is correct that these allegations took place some time ago, but I have concerns that there are two separate victims. Both took place while they were minor students, and the defendant was their coach.
May I respond to simply say my client didn't?
I thought I already ruled on this, but go ahead.
My client didn't. The court did, Your Honor. But my client did not abscond to Florida. He moved there to take it for his wife had a job there, and he was down there. I think actually applying to the police force down there. So this isn't an absconding case where he and his family actually moved to Florida. May I approach with the signed waivers?
Anything else from either side? It sounds like the same argument, so it's going to be the same for bond reduction is denied. Thank you. As to the circuit court arraignment counsel.
Yes, Your Honor.
You waive formal reading of the information.
Yes, we did, Your Honor. He'll be standing mute.
Defendant having waived formal reading, standing mute as to all four counts. Court will enter a not guilty plea. Pretrial in these matters will be set for
September 22nd at 1:30 with Judge Simpson.
September 22nd, 2025, 1:30 before Judge Hammoud.
Thank you, Your Honor.
Bond will continue. Thank you.
May I approach and sign the information?
Yes, you may.
We're trying to,
Ma'am.
a conflict counsel is.
Okay. Thank you very much, ma'am. I do appreciate you very much. Thank you. I'm trying my hardest to take care of all this.
appearance, please.
Thank you, Your Honor. Cassidy Kachukas for the people, appearing requesting permission to practice pursuant to MCR 8.120 with Abigail Tipper as my supervising attorney.
Permission is granted. I have Mr. Metcalf present via polycom.
And I called Mr. Metcalf last night, see the number provided, called his name 3 times, stay in court, he's not present. I was just appointed to this matter yesterday. I was made aware, Assistant Prosecuting Attorney, that he's in Indiana in the fear of his own. So I humbly ask the court for a brief adjournment.
The concern that the court has is he appeared last week virtually, and when he didn't realize his camera was on, he appeared to be engaging in the use of illicit drugs. I ordered him to be drug tested and to appear in person today. So I will be issuing a bench warrant.
Yes, sir.
I recognize that I believe he is on parole in Indiana, Allen County, in Fort Wayne. So I'm sure it's his parole officer likely has some connection or contact to where he is.
Your Honor, is that warrant going to be nationwide pickup since the defendant's out of state?
That is correct. Any additional matters for the record?
No, Your Honor.
Thank you.
Everybody have a good day.
Thank you. Thank you. Honors due without counsel. However, my records do reflect that he requested a public defender and that conflict counsel needs to be appointed on this matter. And that is because somewhere along the line, there is a conflict and they have not yet identified who could take the case. So this matter is currently scheduled for preliminary examination in person at the court. Mr. Metcalf, I cannot see your face.
So
in person at the court on September 11th, you must appear in person. Do you understand that?
okay, ma'am, I have to let my parole officer know down here.
That's your personal business. That's your personal situation. That's not mine.
Okay.
You must appear in person. Do you understand that?
Yes, ma'am.
Your parole agent should have already been advised that you have a pending felony.
He does. He's aware of that. Yes.
Okay, so you need to do that. I'm also ordering that you undergo drug urinalysis testing today.
Okay. How am I gonna do that, ma'am?
Aren't you on parole?
Yes, ma'am.
Through what agency?
Through Allen County here in Fort Wayne, Indiana.
What is your parole agent's name?
His name is James Jamal.
What's his number?
Let me see. Hold on. It is 260-494-6902.
Okay, we'll treat next week as a follow-up probable cause conference and make sure you have an attorney. We'll see you next week, September 11th at 8:30 in the morning. Do you have any questions for the court, sir?
Ma'am, is there any way I can please do that through Zoom?
No. Any other questions?
I don't have no way to make it, ma'am. I'll try to figure it out my best I can.
Yes, thank you. Thank you.
Thank you.
Any additional matters for the record?
Not with Your Honor.
No, ma'am.
Thank you. Your bond will continue. You're all set.
Thank you.
I don't know why Mr. Kane is still here when we just called and they were supposed to be transferring.
Let me call right now.
Mr. Kane, you're going to be transferred.
Court calls the case, People versus Lawrence Peck.
Ready, Your Honor.
Trevor Mabel for the people. Lawrence, how we do? And Joe Simon on behalf of Mr. Peck. Didn't hear that.
Lawrence Peck. Thank you.
Your Honor, we adjourned this once before to allow another charge to ripen, which it has, which is an OWI second before Your Honor next week. They arise out of the same incident. My client is now, I've been informed the people, he's interested in entering the 14A sobriety court, and I'm arranging for him to be screened for that process. I'm asking the court to adjourn this probable cause conference probably around 3 weeks if the court would entertain that.
Weeks. I had the 30th of October.
Just to be safe, it's probably the latter date is the.
Any objection from the people? We adjourned October 9th, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you.
Thank you.
Court does call the case, People versus Anthony Williams. In case. How many AG cases, Joe?
Just two. Good morning, Your Honor. Assistant AG Clarissa Williams.
Assistant Public Defender Chelsea Vergil with and on behalf of Anthony Williams, please state your name.
Anthony Williams.
Your Honor, I'm asking for, if possible, 1 week adjournment. I did receive an offer from the Attorney General yesterday after I was speaking with Mr. Williams. So just to keep things moving along, asking for a very short adjournment.
1 week would be the 18th. That objection, probable cause conference, September 18th, 2025, 9 a.m. Bond continued. Thank you.
Thank you.
Court calls case, People versus Brandon Kelly.
Assistant Public Defender Chelsea Vergil with and on behalf of Brandon Kelly. Mr. Kelly, can you unmute and state your name?
Yeah. Yeah, let me see. I got it. All right, Brandon Kelly.
We're asking to adjourn this for media, and may I address bond?
Probable cause conference will be adjourned to September 25th. Yes, that's about.
We are asking the court to consider a personal bond or a very low cash bond. Mr. Kelly has a plan for, if he's released, he would stay with his parents. He also would be in treatment with CMH. He does not have a criminal history, understands his bond conditions, and I think it would be beneficial to him to get that mental health treatment out of custody. He has been in custody for 70 days now.
Only on this case?
He had another misdemeanor. My understanding was that the bond was set at $100 on that just to get time served.
He does have another case. I'm sorry, I don't know if Ms. Marco is finished. It's completed there.
I'm finished. Thank you.
So Your Honor, we do believe that Mr. Kelly still is in a danger. With Mr. Kelly, while it is true that he has a CMH plan, it's the result of being petitioned while he was in jail. That petition last month because he was threatened to kill a jail staff member, to injure jail staff. He refused to take any medication. Your Honor, it was indicated that I checked the register of actions. He just had his hearing 2 weeks ago. And at that hearing, he was found to be a person in need of treatment, that he, one, is a danger to others, and also doesn't necessarily recognize the amount of treatment that he needs. And
that treatment is completed.
Okay, thank you for interrupting. Go ahead, Mr. Thomas.
So Your Honor, I know on the petition, that it did indicate, that the petitioner was recommending that the jail be able to give Mr. Kelly shots of antipsychotic medication since he would not take medication. So while I'm sure in the last 2 weeks, he might be benefiting from that medicine, I feel about whether he will continue that medication once he's released. The allegations here, I think, indicate a danger to the public. If there had been some ongoing treatment that he seemed cooperative with, I would be different. But in this case, he's accused of punching a Target employee in the face where he busted his lip by using a watch wrapped around his knuckles as a makeshift metal knuckles. I would also note that in the other case, he was accused of following a stranger to a library bathroom. When that individual turned around to find out why Mr. Kelly had followed into the stall, Mr. Kelly asked him what he's looking at, and then he punched that individual in the face, giving him a black eye. So with such a short amount of treatment, given that he's had a history of non-compliance, I don't think at this time that it's safe for the public.
Anything else?
I would just say we're not denying that he has had, mental health struggles and he is going to get help with that. I think that the circuit court order for assisted outpatient treatment is a determination that it is appropriate for him to be getting outpatient treatment rather than being hospitalized or some more restrictive alternative. I also think with a supportive family, he would do well in that environment. So we still ask the court to consider that.
Motion for bond reductions denied. Bond will continue. Thank you.
When's the next court date?
25th.
Thank you, Your Honor.
Court calls case People versus Imbaye. Yeah.
Good morning, Your Honor. Assistant Public Defender Dabby Leba on behalf of Mr. Ngai, which I believe is the correct pronunciation.
Yeah, bye, Baba.
Mr. Ngai, could you please state your name, sir?
My name is Baba.
And good morning, Your Honor. Assistant Attorney General Clarissa Williams on behalf of the people.
And Your Honor,
what are we doing?
And Your Honor, I do have a green sheet. We would be requesting an adjournment. I would ask if the court could provide 60 days. I realized that was a long shot, Your Honor.
Oh, I was going to listen to your reason for it and then tell you no.
I would like the court to hear, I realize it's long, but I do want the court to hear my reasoning, which is Mr. Ngai has a significant amount of arrearages. We do have an offer that will be contingent on him paying off those arrearages very significantly to around the $13,000 amount. And he believes he can do that if he's given that 60-day adjournment.
Is it a misdemeanor resolution?
The offer would be for a delayed sentence at circuit court.
So wouldn't it be wise to waive it to circuit court, see if he does it, and then they can? That would seem to me to be the way to handle it.
I don't disagree.
It doesn't matter to me.
I don't disagree.
I'll keep this one too, but
I don't disagree, Your Honor. I did email Ms. Williams to ask if she would agree to hold that offer open at circuit court, but in the absence of a reply, I felt it was best to request the adjournment.
Madam Attorney General.
Oh, well, I mean, it's like Judge Simpson said, those offers were contingent upon you waiving the preliminary exam. So either way, I think at some point you would have to do that. I mean, of course, you can wait. And if you have it at that point, then we can waive it and go and finish the process. But again, they were contingent upon you waiving the preliminary exam.
So if I understand, that offer would be held open if Mr. Ngai were to waive today.
If it's contingent upon, it seems to me would have to.
We do this all the time. Yes, it would be.
Thank you. Thank you, Madam Attorney General. Would you be okay with completing this issue at circuit court? So you would skip the exam.
Your other case, we adjourned out 1 week, correct, Madam Attorney General?
That is correct.
All right, let's just do this so that they can have a full conversation.
Thank you, Your Honor.
Probable cause conference will be adjourned to September 18th, 2025, 9 a.m. Bond continued. Thank you. I think that's your last case, isn't it?
It is.
Okay. All right, have a good day.
You too.
Court calls.
Not today, because I had no way of contacting them until today. And
these were just reassigned to me as of like last week. And these are all on bond and there was no contact information. I have
talked to them and
most of them, we were calling them in as I was talking to them.
I know. So here's my frustration. Okay. That's why I got you in there. I said, you're right into the game. Richard Brady, come on up. Richard Brady, for example. This is a year old, going on a year old. And not much was done like the other ones. It's almost a year old. It's a state jail felony. And the stats of not only the court, the other court in this county and in other counties. And we shouldn't, announcements should be in a matter of months and a disposition needs to be we're still in the very first stage and it's not your fault, but why? And I know in this case, but he was indicted in October 23rd, on October 23rd of last year. And I'm Brady, Judge. I'm looking at Richard Brady. I have a few cases.
He's not free.
Okay, this is just the first one. 24 CR 454. Then 24 CR 2454. It's this one. And then I'm sorry. 24 CR 2454. The first one indicted 12/18 of 24. Then 24 CR 2455 was indicted all be the same day, 12/18 of 24. And then the third one is 24 CR 2198. And that indictment was October 23rd of 2024. So he's got three of them. And there's not really anything that's been done except just resettings. I mean, this is what's frustrating. This isn't going to happen. It's they go back, say. First resetting was November 20th of last year. Second resetting, December 24th. Third resetting, January 25. So it's on. I mean, it's just installing. I bet it was laser, and that's not. I can understand that was the back. I never filled the next one, fifth one, March 17th, 6th, April 14th.
I'm making some adjustments. Can't test this one right now.
Seventh and June 3rd. And those were all different from finding.
Yes, it's very typical that happens.
July 18th was the next one.
It's a specific update.
And then August 21st, that's 10 resetting. I mean, that's 10 resettings and we're on a state jail felony. It wasn't that hard.
To be fair, Judge, he has 2 second-degree felonies.
I'm looking at 2198, and then you're right, but I mean, still 10 resettings on anything is capital murder is long. Yeah, I mean the indictments here 20 a year ago, and then going on a year ago in a month. Then he gets the other two on December 18th. which is interesting because why would anybody? Yeah. He posted a bond in 24 CR 2198 on September 9th of 24. The indictment, I guess that was when he was arrested. Then the indictment in 24 CR 2198 occurs on October 23rd, 2024. So he's indicted on 10/23/24. And his dad has been he's supposed to, while he was posted a bond while that indictment was pending, it's alleged he commits these 2 second-degree felonies on my watch, which are aggravated assault with a deadly weapon, 2 aggravated assaults on December 7th after he. What's his bonds in these two? In 2455 and 2454. Because he did that after he had posted a bond and was on indictment in a previous case.
$30,000.
On each one?
I'm looking at the other one. Just to make sure of it. Correct. On each of the aggravated assault cases, it's $30,000 each. On the theft of a firearm, it's a $5,000.
Yeah. All right. Okay, what's our announcement? We've been doing this for about 8 resettings. And I know you're new, but that's why we've changed for the better. Moving things forward.
Got this. I met him this morning because of the contact information. I understand the court's frustration, but
yeah,
also at the same time,
he's going to his bond. You can stay over there. I'm considering increasing your bond based upon the circumstances of all of this. So what are we going to do today? Just reset it again?
If I would ask for one more reset to get so I can actually sit down and talk with him about his case, because like I said, Judge, when on all the case information today, all of it came up without any sort of contact information. All of them are out on bond. So I'm literally being able to meet with him for the first time as we're meeting in court today. It's not meant to be dilatory. It's just meant to be.
Why aren't we meeting them though? Like before we get to you, I can maybe work on some other ones. Maybe y'all can talk about with everybody. They're all here. Let's see if there's something that can be accomplished now that they're all here. Otherwise, we're going to all take off, and then you're going to have to chase them down on a phone call.
I agree. It's just the court was starting to call names when we were meeting.
Okay, Reagan, Manalvi.
Never came back to the back.
Yeah.
So
is Reagan Manalvi out there? Thank you. Because I've only got 2 defense lawyers working in these cases today. People on Sean, Sam, where are you? Sean, Sam? Okay, we can take you up. Come on up. In this cause number 15-22909, a long time ago, you were placed on 10 years deferred or unadjudicated probation. Going on 10 years. And
Mr. Marks, as far as you're writing in.
I think what we had is a request from the probation office for a judicial review
You're right.
back last month. And
Place the bus.
I must say, I don't do have an administrative hearing. It's refreshing.
Swear or affirm to have a few follow through and have another for something like. Either can put them in. Okay, I said, you can have one house. And my name.
So what happened is we're kind of arrearages of fees, and you had a fine of $1,000. And other costs. Let's say now we're in arrearages $5,524, which is again unheard of here. That's not what's normal. And let's see, y'all had a hearing back in April, and it was agreed with you that you paid $2,000 prior to today's hearing, and you have paid a total. Listen, I'm sorry. Since the defendant's administrative hearing was, the defendant has paid a grand total of only $200 since April, May, June, July, August, 5 months. Just $40 a month. Probation has requested you provide documentation regarding your back child support and why the assessed and reasons for why the assessed fees have not been paid. You failed to provide anything. I see the rest is kind of right. Go ahead. Probation.
Yes, sir. So, Mr. Sam is upcoming on his expiration. This case is set to expire September 27th of this year. So he's got a little less than 10-ish days, 15 days prior to expiration. Like the court said, he does owe, as of today, $5,584 in arrearages.
That's not what important. He made promises that he's not keeping.
Yes, sir.
How much have you gotten? How much has he paid since April?
Since April, we've received $200.
Which is about $1 a day.
Yes, sir.
Anything you want to say before I order a motion to revoke probation be held? Then that's what I'm going to do. I don't think he's not trying. Others do, and you had a responsibility, and you got nothing else to say and no explanation. I want something. We're going to file a motion to revoke probation on this.
Yes, sir.
This is aggravated assault. Are you kidding me? You're looking at 20 years in prison, sir. Because you won't even pay your fees.
So
these aren't much.
I just got a new job, sir. And
your mom's was. I can't see her.
I just got a job, and my parents are gonna help me. I have them sitting over there.
Sir,
you get this.
I'm going to remind you, you've been on probation for 10 flipping years. Have you been a bum just for 10 years? I don't mean to be brutally honest, but where's you haven't paid at all. Hardly anything in 10 years, which all probationers are responsible for. Yeah, I know you understand, but in 10 years, you couldn't find some work to pay?
It just
something that keeps you from going to prison for 20 years? All right. I worked the day I turned 16. I've worked ever since the day I turned 16. I can do it, and I'm not special. I can do it. Anybody can do it. Are you healthy?
Yes, sir.
All right. It's a matter of effort. And most people don't need 20 years in prison as a carrot in front of them to take care of business. Do you have any income at all?
Yes, sir. I just started a new job.
Before today?
Yes, sir. Yes, sir. I was looking at it. I was a deckhand at Associated.
How much were you making an hour?
$17 sir.
Okay, that's pretty grand.
Support. I know I had child support taken out of my check, and then I had to provide myself with my living expenses And, I had other things come on. I had to pick up a far note, which I'm never, responsible for. So there was a lot of things that took place, Your Honor.
All of those things sounds like me. I mean, I got going through life. We all have expenses.
Yes, sir.
Things you plan for and things you don't plan for. But going to prison for 20 years is something that becomes, prioritized. All right. You got to choose which one. I mean, it's a matter of choosing which is.
You can just buy me some more time, sir. Please, I would really appreciate it. Have mercy and grant me more time to get this paid up. I'm in a position to work now steadily, and that's all I need. That's all I'm asking.
How much time?
At least a year. That's it. To get this $5,000 off me. If you can grant me a year, I had this wrapped up. I've done everything I could as far as taking care of my business, following the rules, staying, out of any trouble or anything. And that's my only hang up. It's just the finance.
Well, we can't. We got a problem. We got a termination thing coming up.
Yes, sir.
Well, the only way we can hold at the end of 10 years. By law, your probation terminates unless a motion to revoke probation is filed. We're going to have to file a motion to revoke probation. You can get me that. You need to give me anything else, or is this administrative hearing going to be good enough?
I'm not too sure, Your Honor, that the recommendation on there is for a judicial review today. So if the court,
I know, but we got.
If you request another one, I can prepare another one and send it to the court today.
We have to have. Thank you. That's what I would request.
Yes, sir.
Because we have to file something on or before
27th.
9/27.
Yes, sir.
And it would be a motion to revoke probation. You will be arrested. That's just the way it comes about. But what I'll do is the bond is set as a recognizance bond, which means you don't have to post any money. You got to appear. You got to show up, they process you in and they process you back out.
Yes, sir.
But there'll be this is the bond. It's personal recognizance, which means you have to appear timely. And then we're going to need a hearing in 4 weeks to see where everybody is on this. So the total amount that he needs, our goal, he needs to reach is what?
$5,584.
We're going to need that in installments. I don't want to wait till 5,000 is reached because that could be a while. A little bit of it when you can, but we'll review in the first. For us, it'll be 4 weeks. So by that time, you will have been processed in and out on the motion. The motion will be pending, but we'll hold it in any action in abeyance as long as we're satisfied that he's doing what he can to pay as soon as possible. So now at the end of this, in a few weeks here on this anniversary on 9/27, all the fees stop, right?
Yes, sir. Everything has been assessed to today's date. So
okay,
the $5,584.
That's his goal.
Is the max. Yes, sir.
Okay.
It's not going to go up any.
That's your goal. If you got that tomorrow, all things being the same, I dismiss the case. You're not even found guilty. You're on deferred probation. But you don't want to foul it up by a payment thing.
Yes, sir.
When you're able to pay. All right, it's frustrating, but it's not the first time this happens. A lot of people on probation feel well, they got to pay their other bills. Probation, it can wait, but it's not forgotten. And we're talking all the monies here are taxpayer monies.
Yes, sir.
That goes to the taxpayer who pay for the option of probation, supervision, other than prison terms. So you've been free because of the taxpayers' monies that have paid for the option of fix the problem and move on with your life.
Yes.
But you got to pay for it, like I do too. My taxes, but here you have kind of a direct tax from probation fees. So we'll review it in 4 weeks and see where we are. And once again, whenever you can get this, as soon as that would happen, he'd send me something going, he paid. All right. And then there'd be a dismissal, which dismisses the case.
Yes.
Okay. Well, it'll be in 4 weeks. Yes, sir.
Sir.
What's your resetting? Oh, okay. Did you say you were going to get another job, or is
I just started the job.
that started that one?
Yes, sir.
Okay.
Yes, sir.
What do you do there?
We do urinalysis samples. We go and we test people doing, motor urinalysis. So,
Okay. Well, that's a responsible job.
yes, sir. Yes, sir.
Okay. Don't foul it up.
Oh, no.
Okay.
Thank you, y'all.
Yes, sir. DeMarcus Jones.
He's a pretty much.
And I had Harlem Briggs too.
I do. He's also a plea.
Okay. Which one you want to do first?
Okay, sure.
Harlem?
That's fine.
He's Harlem?
Yes, sorry, we'll have to go check.
Harlem Briggs, and then we'll do DeMarcus Jones. Mr. Briggs? Thank you. Harlem Briggs. DeMarcus Jones. You are Harlem?
Yes, sir.
25 CR 111 is called the state of Texas versus Harlan. And your middle name is Dreamist. Did you know that? I don't think I've ever known that. I've never heard that. Briggs. And you were here with your attorney, Ms. Minaldi, and the state's attorney. Does the defendant waive a formal reading of the indictment and arraignment here? Can we proceed in summary?
Yes, Judge.
In summary, this indictment alleges that on or about December 17th, 2024, in Jefferson County, Texas, you committed the state jail felony of burglary of a building. Do you understand what you're charged with here, sir?
Yes, sir.
A state jail felony, if convicted, means that you face a term of imprisonment in the state jail no less than 180 days, no more than 2 years. And in addition, a fine may be assessed not to exceed $10,000. Do you understand? So the punishment rate.
It says, it's fine with all. Legally, it's just more than that. So.
I'm going to show him what we have to do to write on this stuff while he was here. Because that's the way this has work or don't work. An agreement has been reached in your case. You would be pleading guilty, sentenced to 2 years in the state jail. That would be suspended. You would be placed on regular probation for 5 years, ordered to pay restitution in the amount of $482.86 to the complainant in this case. Is that your understanding? That's who's named in the indictment. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead to this, sir? Guilty or not guilty?
Yes.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty? Yes, of course. Okay. I show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it? Discuss it with your attorney? Are the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence and without objection, it's admitted. Among other things, this states you were mentally competent to enter your guilty plea, and it's completely involuntarily made. You know what you've been charged with because it's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses, and you were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All of this is true, so help you God.
Yes, sir.
State's Exhibit 1 is made a part of the record for all purposes. Pre-sentence report is made. And again, how do you plead to this, sir? Guilty or not guilty? You're pleading guilty voluntarily and because you are guilty. So, all right. I'm going to make the following findings that you are indeed, the court finds, pleading guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence from State's Exhibit 1 admitted here to support your guilty plea to find you guilty beyond a reasonable doubt. And I now find you guilty beyond a reasonable doubt of this state jail felony of burglary of a building. I am following this agreement. You're hereby sentenced to confinement in the state jail for 2 years. That will be suspended. You are placed on regular probation for 5 years. And restitution, among other costs, will be paid in the amount of $482.86 to the complainant in this case. When can that be paid?
My first payment will be on the 20th.
When can? No, that's not the answer.
He paid off. Was there?
I want him paid as soon as possible because, for example, like this is going on a year old, and whatever they lost, they've lost it now for a year. You got to get the money, reimburse the person. How much time do you need? For $482.86. Is that what that paid first?
He can for sure commit to $100 a month, Judge, but if he can pay it all off quicker than that, then he will.
You got 4 months to do it. Okay. No, I'm going to let's get this before Christmas, 3 months. Okay.
Okay.
That's 90 days. All right. There will be other terms and conditions which are normal and customary. If you do well, your probation is shortened to 1/3 of the time.
Can you right my wrongs, Judge?
I'll say fix it. We'll fix it.
So I get it straight today.
Yes, sir. Okay, good. Thank you. Anything else? Thank you. Please seek probation. Next is DeMarcus Jones.
Yeah.
Twenty-five CR 819 is now called. You are DeMarcus Jerome Jones.
Yes, sir.
Present with Ms. Nally, your attorney and the state's attorney. Does the defendant waive a formal reading of the indictment? In this case, we proceed in summary.
Yes, Judge.
In summary, sir, this indictment alleges, it was handed up, by the way, in July of this year, that on or about May 23rd, 2025 in Jefferson County, Texas, you committed the state jail felony of unauthorized use of a motor vehicle. Do you understand what you are charged with here?
Yes, sir.
If convicted, you face confinement in a state jail for any term of not less than 180 days or more than 2 years. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, yes.
An agreement's been reached in your case where you would be pleading guilty and placed on deferred or unadjudicated probation. You wouldn't be found guilty for up to 5 years in this case. Restitution is the big thing. That's $3,503.37. That will be ordered to be paid. You need to get that, again, like the previous defendant, getting the people paid back who were victimized. That's how you fix things quick.
Yes, sir.
Is that your understanding of the agreement?
Yes, yes.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Sure.
How do you plead in this, guilty or not guilty?
Guilty.
9/11 today.
It is, Judge.
It's a special day in history. Are you pleading guilty voluntarily, that is on your own free will and because you are guilty?
Yes, sir. On my free will.
No. And you're guilty.
Yes, sir.
Okay, I'll show you what's marked as State's Exhibit 1 there. Did you sign that document voluntarily, understand it, discuss it with your attorney?
Yes,
Are the contents true and correct?
Yes, sir.
State's Exhibit 1 is tendered
No
into
objection.
without objection. It's admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You read it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, consultation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All of this is true, so help you God. States Exhibit 1 made a part of the record for all purposes. And again, you've had a chance to think about it. Again, how do you plead on this, guilty or not guilty? I'm going to accept your plea of guilty. If nothing further, I'm going to find you are pleading guilty voluntarily. You're mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt of this state jail felony offense, which would you would carry around on your back your whole life. But I'm going to defer any finding will not find you guilty so long as you follow the terms and conditions of probation. And if you do that, you also will be shortened to 1/3 of the time. We don't need people on probation if they've got it and they're fixed and they're in the right direction. Restitution is so important. $3,503.37 shall be ordered to be paid to the victim in this case. How long will that take to pay, do you think? I know I wouldn't be able to write a check for it today, but less than 10 months. I'm gonna why don't we give you a year? Okay, then I'll give you that as if you pay off earlier, that's really important. Yes. To me on how this gets disposed of, because if it's shortened, you're fine. It's dismissed. You can move on with your life. Not found guilty. You don't have to say I've been guilty of a felony or anything else. If you fail on it, though, your probation can be revoked. You could then be found guilty and sentenced up to 2 years in the state jail, which is not what we all have. But you can fix this. Yeah. And thank you. I'm going to write my little name. These are the deferred or unadjudicated probation orders that it's for 5 years, but I shorten these every day because of good work by the 93% of the probationers are successful. Their watch. They're great. I'm just so honored to work with this team of folks who care so much about fixing problems. And everybody, people the 7% who fail, that's and that's way higher than the national average of about 75%. So they do well. So it's not your fault if you fail. You need to carry your weight on this one, and you'll be fine. If there's any problems, though, you go to your probation office, tell them ahead of time so they can help fix it. Okay. All right. Thank you. Please see the probation officer. Here's Jasmine. Yeah. And we now call cause number 25 CR363. The state of Texas versus Jasmine Young. That is you, ma'am. You're present with your attorney, Ms. Minaldi, and the state's attorney. I know if they were here, they'd want to be here. They're on their own. They're busy. All right. You are charged, as you know, with the 3rd-degree felony of tampering or fabricating physical evidence, which carries with it up to 10 years in prison. That's scary. This one's kind of unique, isn't it? You can find a lot of those things on the floor now for a couple of weeks.
We make it as difficult as function.
Take all of it, put it in your foot down better.
I already cried and got some. I'm making sure.
When I get the cake, it's really bad.
Unique set of circumstances.
Not for me.
Oh, this one was indicted in March earlier this year. What is it? Oh, it's an announcement.
I've been speaking with Mr. Boyd about the discovery of
How's that?
space. I am gonna schedule.
He's speaking back.
He is speaking.
Yeah, there's some, we
here.
call that dialogue.
We are working.
That's great.
But I do need to schedule an appointment to come view videos that are, no, with a different defendant that could be relevant to Ms. Young's case. I need to see which ones are relevant to.
Pursue the truth.
And
Pursue the truth.
get copies of those. If I could have 5 to 6 weeks to accomplish that, that would be amazing.
No, but I'll give you 5 or 6 weeks.
Is really, other than.
That's great.
Great minds think alike.
Perfect. Thank you.
That's great. Thanks. Get a reset. Is that it?
That's it for me.
Okay, thanks. You come from there. Hey, Reagan, let me see about one thing.
Sorry.
It's gonna take a minute. One more short. Let's see, I'm gonna do all the paperwork for Mr. Preston. Parkinson, I'm sorry.
Dalen? That's you, Dalen? Yeah.
Okay, and then
We got Deanna and Megan.
I think, I need to work on Mrs. Scott some more. There's some issues, I think, with the.
Where's Megan? What's your final answer?
I need a reset for her.
Come on up, Miss Scott.
Because I have some issues about the stop. Now I'm gonna live with her tomorrow then.
Yeah.
Okay.
This is your Megan Simone Scott, and you're still at 1019 West 13th?
Yes, sir.
Okay, good. You're not any longer at 1225 Augusta?
Yeah.
Okay, I'm gonna change that.
So kind of.
And it's Port Arthur, you're still at Port Arthur?
Yes, sir.
As you know, you are charged with third-degree felony of unlawfully carrying a weapon in a prohibited place, which carries with it up to 10 years in prison. So it's serious and needs to be handled responsibly. What do you want to do today on?
Judge, if I get another reset, I want to.
How much time? 4 weeks good?
That's fine.
All right, reset 4 weeks, get a reset. There you go. Thank you.
Stop.
And I've got Deanna Preston and
I think both of which are going to think of me taking care of. And
then Richard Burley.
I'm working on the paperwork.
Great. Thank you.
Correct.
We're in short recess.
Okay, it's People versus Amanda Corwin.
I'm gonna bring a book of people.
And Your Honor, Joe Simon standing in for Ms. Corwin. She's making her way to the podium. Amanda.
Standing in for.
Well, I'll explain in just a second.
Okay.
State your name, Amanda.
Amanda Corwin.
Your Honor, I appeared as a courtesy from a professional referral for Ms. Corwin at her arraignment. I believe that.
You did a courtesy?
Yes, I did.
Oh, okay.
It was really kind of him.
And I believe.
Shocking. No, go ahead.
At the time, I believed I would be filing an appearance of counsel, but I'm not. Ms. Corwin is seeking other counsel. And I told her I would assist her to ask for an adjournment for that to happen.
Fabulous.
Okay.
Can give him that.
How much time would it take you to get an attorney?
You want 2 weeks?
Can I just have 2 weeks? By then I should have most of
The
it.
25th?
Yeah, that should work.
Any objection from people?
No, Your Honor.
Probable cause conference will be adjourned September 25th, 2025, 9 a.m. And you always do reasonable things.
Well, thank you. Your
Thank you,
Honor.
sir.
All right. Look, and you're all set.
Thank you.
Court does call the case, People versus Moses Steger.
Cover made well for the people, Your Honor.
Assistant Public Defender Virgils with and on behalf of Moses Steger. Please state your name.
Moses Steger.
Thank you.
You're on the case that I am on. I am asking to adjourn. Mr. Killawald approaches to do something else on his cases.
Killawald and 25 F2, 1193, and
1351.
Correct. Judge, I met with this young man last night at the jail. On my 2 cases, he wants to proceed to preliminary exam. What I have, Judge, I have to be in Detroit on the date you've been giving for the 23rd. Is it possible to
Put it down 1 second. On your case, you're looking for an adjournment. That's on 1274.
Thank you, Your Honor.
Is that correct?
Oh, yes, yes.
So on that matter, I'll adjourn the probable cause conference to September 25th, 2025, 9 a.m. Bound continue. And then here's a reference to your preliminary examinations. All discovery is complete.
Yes, Your Honor. Wondering if we could go past the 23rd.
Yes, I can set it for the 30th.
I'm sorry?
I can set it for the 30th.
That would be fine, Judge.
Your Honor, I'm sorry to make this difficult. Is it possible to get mine adjourned after that preliminary exam?
You had that file. I give it to you. Because they're gonna change your mind. So let me know.
Oh, this for me?
So you want the 30th, Mr. Hill?
If it's possible, Judge.
It's always possible. So
You're very considerate, Judge.
preliminary examination will be set in the 2 matters for September 30th, 2025, 9 a.m. That's before me at noon.
Yeah. Okay. Thanks, Judge. I'm come down with the video.
And then you wish to have a date after that. Is that correct?
Yes, please.
Bond on that these matters will continue on the case ending in 1274. I will set the probable cause conference to the next date available after the 30th to October 9th, 2025, 9 a.m.
Thanks, Judge.
Thank you. Thank you. Court calls the case People versus Devontae McFarland.
People.
Oh, he's on Zoom. Good morning, I'm Rob Jekyll on behalf of Mr. McFarland. Would you?
McFarland, can you unmute and state your name?
Is it?
Yep, we can hear you. What's your What's your name?
McFarland, can you state your
Jonathan
name?
McFarland.
Thank you.
Judge, may we approach very, very briefly?
Jonathan McFarland.
Yes.
And a report. It's my understanding you're going to adjourn this till October 9th.
Probable cause conference will be adjourned October 9th, 2025, 9 a.m. Bond continued.
Thank you. Mr. McFarland, I'll come down and see you again, okay?
Yes, sir. Thank you.
Thank you. Court calls the case, People versus Anthony Alexander.
Your Honor, Sam Bernstein with and on behalf of Mr. Alexander.
Anthony Alexander. Thank you.
We're asking for an adjournment, Your Honor.
Probable cause conference will be adjourned September 25th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Court calls the case of the People versus Stephen Bauer.
Morning, Your Honor. May it please this honorable court, David Burgess on behalf of Stephen Bauer.
Thank you. What are we doing?
Your Honor, today's date time set for adjourned probable cause conference. My client is executing a waiver of examination, Your Honor.
Sir, you're going to waive your right to have a preliminary examination?
Yes, Your Honor.
You understand that that's a proceeding where people have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, Your Honor.
You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution.
Yes, Your Honor.
People also waive their right. Preliminary examination having been waived, defendants bound over to circuit court on all 8 counts.
Your Honor, as to the arraignment on the information, waive formal reading, stand muted as the charges contained.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
September 25th at 1:30, Judge Slay.
September 25th, 2025, 1:30 before Judge Slay.
Thank you.
Thank you. Bond continued. Man, that one I can find. Court calls the case People versus Philip Carrick.
And then on behalf of the people.
Morning, Your Honor. Sam Bernstein with and on behalf of Mr. Carrick.
Philip Carrick.
Your Honor, we're asking for an adjournment. We're still waiting some discovery.
And you're in the discovery, you received it, it's with the OIC, he's on, he's off for a few days, so we should get relatively soon, his medical records from the media and photos. So it should be incoming.
Probable cause conference September 25th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court calls the case People versus Anton Brooks.
And for the others, for the people.
Good morning, Your Honor. Brandon Bird on behalf of Anton Brooks. Anton Brooks.
And Assistant Public Defender Ben Dunaway on behalf of Mr. Brooks on the case ending in 1261. Your Honor, we're demanding on the 1261 case.
Pardon?
We're demanding exam on the 1261 case. And we're respectfully requesting exam.
No, I appreciate it. No, so he'll get his. You keep up with your demands. No. Discovery on both of these matters is complete.
Yes, Your Honor. As far as I know, Your Honor, I was told that there is no body cam in this. I just wanted to make sure that's correct.
There's no video in the case of Mr. Bird. That is RNO that it wasn't on the street. It was actually here at the service center in between exams. Yes, Your Honor. So there was nobody.
Okay.
Oh, and I have it that they pulled him over for 10. for his tent on.
The hallway?
For the RNO?
Correct.
Well, Mr.
No.
Bird's on the. Hold on a second.
Sorry.
Denowith is on the RNO.
Oh,
And
sorry, I thought you were on RNO.
So, do you know when you could provide me that body cam, please? Say what? This last 2 weeks ago. You say what? So we went through this 2 weeks ago.
Go ahead, Neil.
so they're indicating there is no media.
Respectfully, we'd like to, respectfully request exam, yeah.
Okay, would people have their witnesses available the 23rd?
Yes, Your Honor.
Preliminary examination in person of these matters, September 23rd, 2025, 9 a.m. before Judge Fleischer in both matters. Bond will continue.
Thank you, Your Honor.
Court does call the case of the people versus Demetrius Job.
Good morning, Your Honor. Please, Honorable Court, David Burgess, on behalf of Demetrius Job.
All right, what is your name, sir?
Demetrius Job.
Thank you. What are we doing?
We're setting a preliminary exam on this matter.
Discovery is complete.
Yes, Your Honor.
People have their witnesses available the 23rd.
Yes.
Preliminary examination, September 23rd, 2025, 9 a.m. That is before Judge
Barr.
Thank you, Your Honor.
Thank you. Bond continue.
Me too.
Court does call the case of the people versus Quentin Coleman Ebersol.
And then on behalf of the people,
Your Honor, Joe Simon, on behalf of Mr. Coleman Ebersol. State your name, Quentin.
Quentin Coleman Ebersol.
Your Honor, in this case, the people and I are engaged in some negotiations. There's also a little bit of continuing discovery. Ms. Zenda is going to be leaving town next week, but she and I have pledged.
What?
Yeah, that's what I hear.
Oh.
Do I have a new last name I need to learn? Because I keep tripping over Lonnie.
Never know till they get back. We will.
Yeah.
We won't. Sweet. Go ahead. It's been hard, Ashley. I'm sorry.
In any event, we have pledged to try to make a resolution actually before she goes. And we're asking the court because part of that resolution may involve possibly a stipulation as to bond. So asking the court if it would adjourn the matter 1 week, and we will not address bond today in consideration of those discussions.
But hold it, Zenda won't be here next Thursday.
Right, but we're hoping that we will have our matters resolved by when she leaves so that somebody else can just stand in her stead.
She's leaving Tuesday.
She told me.
I'm sad.
Me too.
I'm happy for her. But I'm sad.
I'll be back.
Okay, that makes me feel better. All right. Don't like to do that, but I will. Understanding that September 18th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Let's call the case. People versus Juliet Burns.
Morning, Your Honor. Raymond Cook. Good morning. I'm Robert J. Cool on behalf of Ms. Barnes.
Judge, I'd like to give you a sad story. This is you being the considerate judge you are, this could be a tearjerker, but not being facetious. I was appointed yesterday at 4:00. I met with her last night at the jail. They told me she was in a long line of list people to be released. They didn't know when she was going to be released. I told her if she was released, she had to be here at 9 a.m.
Is this where we get to the sad part? Because she's not here.
She's not here, but
she got released. She's not here. I'll let you.
And she doesn't have a phone. So I called her friend at the apartment who was racing down to the 5th floor of the apartment complex. Judge, long story short, can I get a 1-week adjournment on this matter?
Did you cry? No. She's not here.
Judge, I understand that, but she may have been released at 1:00 last night. All I'm saying is, can we get a 1-week adjournment, please?
Here's what I will do. Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of 10,000 cash surety. That warrant I will not issue until
late September.
September 16th.
Thank you, Judge. I appreciate your. So we could technically walk in next week then.
Okay, technically do anything you want. I don't know where you're walking into. The jail?
I'll just let that go.
All right. Calls the case. People versus Sean Odom.
Alexander, on behalf of the people.
Yes, Your Honor. Brandon Bird on behalf of Sean Odom. Mr. Odom, can you please state your full name for the record?
Sean Martell Odom. Question in adjournment.
Please, Your Honor.
Probable cause conference will be adjourned September 25th, 2025, 9 a.m. Yes, as to bond.
Your Honor, it's come to my attention that Mr. Odom has tried to call the victims listed on the from his own pin 7 times since he was arraigned. He wasn't able to connect, but at this time I'd be asking that his phone will just revoke, given that he's using his own pin to call her listed number after being arraigned, will not have contact.
Mr. Bird.
Respectfully, Your Honor, I haven't been presented with any evidence of that matter, and we just respectfully request that he keep his phone calls until it's presented to me in the court.
Well, certainly you'll be entitled to a hearing, but in the interim, defendant's phone privileges are hereby revoked. With that change, bond will continue. Thank you.
And what?
25th.
25th. Thank you.
Yes, sir. Court does call the case. People versus Cedric Green, no relation.
People.
Wow.
Good morning, Judge.
Good morning.
Beautiful day today.
Well, you're going to change that.
No. Well, Judge, just for the record, Christina Costantino appearing on behalf of Mr. Green. Unfortunately, it doesn't appear that Mr. Green has arrived yet to court. I was
You're
just
expecting him?
Yeah, sure. I was just assigned his case yesterday. So perhaps he has not received my letter yet, asking him to contact me and that sort of thing.
You sent a letter?
I did send a letter, always do.
Did you email?
Just in case. I did email. Yes.
Oh, okay.
Yes, I also called, but I have not been able to get in touch with him, unfortunately. So given that.
Mentioned that letter.
The letter, the mail, it's
Yeah.
not that quick. But I would ask respectfully for an adjournment of this matter so I can have a little bit more of an opportunity to allow the mail to get to him and, contact him.
Really? Constantino, you called them and you sent an email.
I don't know if that
Overwriting
context
on
was
snail mail.
I don't know if the contact info is valid. You never know. People's numbers change pretty rapidly these days.
Bench warrant will issue for defendant failure to appear. Bond will be set in the amount of $10,000 cash surety. That warrant will issue immediately.
Thanks, Judge.
Thank you.
Can't say I didn't try.
No, you did. That was an epic fail. All right. Court calls the case. People versus Sherry Walker.
Yes, Your Honor. Brandon Bird on behalf of Sherry Walker. Ms. Walker, can you please state your full name for the record?
Sherry Walker. How you doing?
All right, we got a little bit going on here today, Your Honor. My client she wants to plea. She completed Don Farms. I did speak with Sister Prosecutor who said if we provide a certificate of Don Farms, that she would allow her to plead to a retail fraud second. Ms. Walker wasn't able to go back and get her certificate.
Go back where?
Go back to her cell to get her certificate. She did ask the officer, and I also
they were a little busy.
Right, Don Farms was a little busy. There's a lot of busy, but I did try to see if I could find Don Farms within the building, and unfortunately, I wasn't able to get a hold of him. So I know Ms. Walker doesn't want to adjourn this anymore. And she wants to take responsibility for her actions and take Sister Prosecutor up on her plea. I'm wondering, first of all, if you have a copy, and if you want
of what?
Of her Don Farm certificate.
That'd be a no.
Okay, if not, then
Can I get it for her?
What?
Later on, can I have her to send it to you later on?
I gotta give it to the prosecutor.
Okay.
Then unfortunately, I did everything I could, but we're gonna have to adjourn this matter. But I would like to address bond on Ms. Walker.
Here's what I'll do. I'll let you address bond if you want. Rather than adjourn what would be a customary 2 weeks, I would adjourn it out 1 week if it's a certificate, because the other paperwork has to be completed for me to take the plea in any event.
Thank you.
Does that work for you, Ms. Walker? I realize you don't want it adjourned, but.
Okay, can you say that again? Repeat that.
I'll adjourn it out 1 week, which would be a shorter time period than I normally would.
Okay.
Because you've got the certificate, it just needs to get there. They also then have to fill out paperwork for me to take the plea. So I'll do that for you.
Okay, I appreciate it.
Okay.
Absolutely.
I'll do that for you. I'm not doing it for him.
Okay, good.
Okay.
Whoever you do it for, Your Honor. I appreciate it.
Probable cause conference will be adjourned September 18, 2025, 9 a.m. Bond continue.
Right.
Thank you. Court does call the case of the people versus Harris.
Morning, Your Honor. Raymond Cook for the people.
Harris?
Twice.
No, Judge, this one's here.
Oh, I told you, he knew his name.
Here and looking very professional, Judge. Christina Costantino, appearing on behalf of Mr. Harris, who is present here. Mr. Harris, could you please state your name?
Malachi Harris.
So I told you.
Judge, this is a date and time set for a PCC. I was just assigned on Mr. Harris's case this week, so we would be respectfully asking for an adjournment of the probable cause conference to ensure discovery is complete.
Probable cause conference will be adjourned September 25th, 2025, 9 a.m. Bond continue.
Thank you very much, Judge.
Thank you. Malachi, thank you. Court calls the case. People versus Preston Jackson.
Judge Fleischer, people. It's Carlo Maribel, who has been talking in and out. She's currently in an out situation.
What do you mean?
She's not present in the Zoom room, but she has been.
Where did she go?
I don't know. There's been no communication, so it might just be a while.
Okay. I'll have to pass your matter We're gonna try to get your attorney.
She had told me she was trying to postpone my date till the 22nd, so me and my co-defendant would come in on the same. That's what she told me. She told me that she had postponed it to the 23rd.
Does he have co-defendants on the 23rd?
I know it's where it's a code.
Brandon Jackson.
We were trying to make the cases meet up, but okay.
First name is Brandon. He's on the third. And that is correct, Your Honor.
So your understanding is she was gonna try to set the preliminary examination for that date? Okay.
That's what she told me anyway.
Your Honor, I had no communications with Miss Maribel, but I have no reason to doubt that.
Well, I don't have a reason to doubt it either. I just can't do that without her being present. So if it were an adjournment, I might be able to slip that by and then talk to her afterwards, but for a preliminary examination, I'd have to have her here.
Yes, sir.
So we'll send you back and then we'll try to get your call back up. Okay. Court does call the case of the people versus James Williams.
Morning, Your Honor. Raymond Cook, the people.
Christina Costantino appearing on behalf of Mr. Williams, who is present via Zoom. Mr. Williams, can you please unmute your device and state your name for the record?
Yes, ma'am. James Henry Williams III.
Okay.
Judge, we have been going through a rather lengthy mitigation process. I did receive mitigation reports this week. And so we will need a little bit of additional time to have some further negotiations now that those are complete. So we'd be asking for an adjournment of the PCC.
25th, September 25th, 2025, 9 a.m. Bond continued.
Thank you very much, Judge.
All right, thank you. Thank you, sir.
Thank you.
Court calls the case of the people versus Eric Brackman.
Trevor Maybell for the people.
Good morning again, Your Honor. Assistant Blood Defender Davi Lebo on behalf of Mr. Brackman, who is in custody.
That's what I have. See you back there, Brackman?
Yeah.
Who do you have up? I'll take whoever you have. Huh?
We'll get him.
Okay.
Eric Brackman.
Thank you. All right, what are we doing?
Your Honor, I do have a green sheet. We're going to be requesting an adjournment. I wasn't for some additional negotiations with the prosecutor. I was informed earlier today that they filed an amended complaint increasing the charge to third-degree fleeing and eluding.
Your Honor, that's true regarding my intent, except the court's not going to have that. I attempted to prepare it at the end of the day yesterday after discovering a prior felony on the defendant's record for fleeing and eluding, and then wasn't able to have it ready for the court this morning, but I intend to do so.
September 25th, 2025, 9 a.m. Bond continues.
Thank you, Your Honor.
Thank you. I think where's this person? Yoder. They got him. Her. Court calls the cases of the people versus Jessica Yoder.
Christina Costantino appearing on behalf of Ms. Yoder in case number ending in 1282 FY.
And Stephanie Cannon appearing on cases ending in 1283 and 1060.
Wow. Yes.
I'm here.
It was a lot quieter last week.
I haven't said anything.
What?
Yes, it was, Your Honor.
Yeah,
Yes.
you weren't here.
I wasn't here.
Everybody
I missed
commented
you
on how
though.
quiet it was.
I missed this whole thing.
We missed you too.
It was so sad.
Oh, constant. Nobody here missed it. All right, anyway, go ahead. What are we doing?
Well, first, Ms. Yoder, can you state your name for the record?
Jessica Yoder.
Thank you.
Judge, we need a little bit of additional time for further negotiations. We are trying to work out a global resolution for Ms. Yoder in all of her matters. So we would be asking for an adjournment of the PCC.
Are you saying in all of these matters or are there other matters elsewhere?
Well, Judge, she has these matters. She has a violation of probation up before Judge Washington in 14B, as well as one other matter in front of you. That's a misdemeanor matter.
Right. And so the one before Judge Washington, when is that set for?
Judge, it was supposed to be heard this week, but it got moved to the 18th. Is that correct, Jessica? The 18th of this month, September.
So what I'll do is I'll adjourn probable cause conference to the 25th, 2025 at 9. Bond will continue.
Thank you very much, Judge.
Court calls the case of the People versus James Abbott. Can we get
permission? My client, he suffers from, okay. His wife also has a device which helps him hear too. Now it's one.
Okay, will that work for you, sir? Or will that work for you?
It's a little better. Yeah.
It's okay. That's
it. It's not a volume problem for me. I just hear like it's noise for me. So we're amplifying it a little bit more, but it's better.
But will it work for you, or you want the other device? Whichever one, you want the one your wife has, or you want this one?
Let's do this.
That one? Okay, very good.
Thank you. The Honor, today is the date and time set for the probable cause conference. We will respectfully be requesting that a preliminary examination date be set.
Discovery is complete.
To the best of our knowledge, Your Honor.
People have their witnesses available the 23rd.
Yes, Your Honor.
Preliminary examination in person will be set September 23rd, 2025, 9 a.m. before Judge Fleischer.
So I'm not sure if I put my appearance on the record. Did I do that? Lauren Brown?
Go ahead, now put it up.
Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Abbott.
Bond will continue.
All right. Thank you.
Thank you. Thank you, sir. Court does call the case of the People versus James Chapman.
And is that on behalf of the people?
Brian Bowling on behalf of Mr. Chapman.
Thanks.
State your name for the record, James.
James Chapman.
Judge, we're here for a PCC today. I'm asking that this matter be set for an exam, and I believe all discovery to be complete.
Just motion for dismiss.
I agree, but yeah, that'd be nice.
Bless you. Would people have their witnesses available the 23rd?
We'll do our best, Your Honor.
Preliminary examination in person will be set September 23rd, 2025, 9 a.m. before Judge Barr.
Thank you, Your Honor.
Bond will continue. Thank you.
Judge Barr.
Does call the case People versus Tanisha Aiken.
People. System Public Defender again, Apple appearing on behalf of Ms. Aikens. No.
Aikens, will you state your name for the record? Tanisha Aikens.
Thank you.
Your Honor, we're asking for an adjournment for some continued plea negotiations.
Probable cause conference will be adjourned to September 25th. 2025, 9 a.m. Bond continue.
Okay, thank you. Okay.
Court calls case of the People versus Curtis Damon.
Your Honor, the people.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Damon. Mr. Damon, state your name for the record.
Curtis Mitchell Damon.
Thank you, sir.
Your Honor, regarding the probable cause comments, we're asking for a preliminary examination date. I would like to address bond, and there's also a bond violation to address as well.
Yeah.
It's a little bit old. I think it's from early August, late July.
Well, let's get your preliminary examination set. What was the subject?
A positive scram.
So right now he's sitting here with no bond.
Correct, yes.
Okay. Discovery is complete.
To my knowledge, yes.
People have their witnesses available the 23rd.
Yes, Your Honor.
All right. I'll set preliminary examination September 23rd, 2025, 9 a.m. before Judge Fleischer. Okay, go ahead. I have it in front of me now. From June 25th.
June?
That's the one I have. Well, yeah. August 12th, I'm sorry.
Okay.
Enrollment date was June 24th. I'm sorry.
Okay.
August 12th.
Just want to make sure I was coming from the right headspace. So I did have a chance to speak with Mr. Damon regarding the violation. He is going to admit to the violation today for the positive drug or the positive alcohol results. He did, for the court's information and I guess bond, relates bond as well, he did complete 30 days at Sacred Heart inpatient treatment. He got out and essentially relapsed. Right after that relapse, he had a mental health crisis and was hospitalized at
Health Source.
Saginaw. I did speak with his fiance, who's a social worker for Salvation Army, and she did provide me with all the information. He was petitioned by the court for hospitalization due to suicidal ideation. He completed, I think, 12 days there in an inpatient psychiatric hospital, and that's why he missed his last probable cause conference date that was scheduled for August 7th. There was also the warrant in place that was kept in place. So given all that, Mr. Damon obviously has been through a lot over the last couple of weeks. He is back into compliance with his mental health treatment. He's on new medication, and I also verified this with his fiance that is really helping and has changed his disposition. New medication that he wasn't on before. He's also on abuse, thank you. And they referred him to AA, NA, and a support group, which he's been attending since leaving the Saginaw Hospital. So given all that, I think Mr. Damon is on the right track. He was fully honest with me about his relapse and is really ready to get out, get his life back together and stay sober. He's now has over a month sober. So we're asking for his release.
How long has he been in?
10 days.
Okay, go ahead.
And for the violation, I'd ask for credit for those 10 days. And he's willing to comply with any bond conditions the court may order moving forward.
Response.
Your Honor, I have some concerns. The court's aware he was on strength tether. He was still continuing to drink. It sounds like he was released inpatient. After that, he still continued to drink. What's been happening hasn't been working. And I don't know what else we can do other than keeping him in custody at this time in order to ensure that he continues not to drink and continues to remain sober. I have some concerns given that the underlying facts in this case involve his drinking as well. The report indicates he also had some warrants out related to some alcohol offenses at the time. He was threatening to harm another individual and being rowdy and obviously resisting police officers due to his intoxication. So I just have concerns given this pattern of drinking, especially while on bond, his inability to control his drinking, that if this court were to release him, that he would just continue drinking and violating them.
I think things have changed. I think Mr. Damon admitted he relapsed and late July.
Here's what I'm gonna do. I'm gonna get through preliminary examination to his violation. I'm gonna sentence him to 30 days, credit 10. The balance he's to serve. And then this will be before Judge Fleischer can take a fresh look at it at that point in time. All right. Thank you.
Thank you.
Thank you. Court does call the case of the people versus Philip Barnhart.
Actually, both for the people in both matters.
Assistant Public Defender Ben Dunaway on behalf of Mr. Barnhart, who stands to my right. Would you state your name for the record, please?
Philip Barnhart.
What are we doing?
Your Honor, Mr. Barnhart is prepared to waive his exams. I think there may be another issue that the APA wants to bring up, though.
The court received the bond violation report from Community Corrections.
I have a report dated September 10th, the progress report, yes.
Yes, Your Honor, and I understand that the defendant was released from jail on September the 2nd, went to Community Corrections to test on September the 3rd. And when he tested on September the 3rd, he tested positive for cocaine, THC, benzodiazepines, and Suboxone. I understand also that this was his first test, so there is an argument that he may not have been on bond at the time that these substances were consumed, therefore it may not be a bond violation. However, I did double check X jail and he was booked on August 31st and released on September the 2nd. So there were 3 days in custody. It's possible that certainly the THC could have been from before. The cocaine, I'm less certain of, with extremely heavy use. Maybe 96 hours on cocaine, but no matter what, these are OWIs at least 4 and 5, and there's another pending OWI in Wayne County. I'm very concerned that he is not able to control his substance use and is a danger to the community.
Your Honor, I believe there's a window that would make this not a bond violation. I think if he would have used on August 30th or the 31st.
But if this is a 5 and this is showing up in his system at all, I would consider him a danger to the public and that his bond is inappropriately set. So I'll let you make your argument, but.
Can I have just a second, Your Honor?
Sure.
So, yeah, I just think there's possibilities that he's not used after being arrested, and those.
What?
I mean, cocaine could stay in his system for up to a week if there's heavy use. So the failure.
Let's say, well, I don't know, a week, but let's say I agree with you regarding that. Then his bond, and this is what I'm saying to you, then his bond on these operating while intoxicated, I have 2 in front of me and there's another one in Wayne County. Then I think that his bond in these cases is inappropriately set. And what I mean by that is that I clearly have these 2 cases. There's the other one in Wayne County. He's got priors and he's still using.
I think I'm fine. I think that's all factually true, Your Honor. Or he's at least not passing the test. Would the court be willing to have him test today?
Would he come back clean?
Yes, sir.
But here's again my problem, counsel. My problem is really the danger to the community. Because I have an incident that occurred in February of 23. This other one occurred in July of 2023 or 23. He's got a pending Wayne County one. He's got prior ones and he's still using. So I don't know that he should be out because at some point luck's going to run out. He's going to get behind the wheel and he's going to take somebody out.
I don't have a vehicle.
Your Honor, I don't believe he's driving. The test certainly indicates use. Look, drunk driving is absolutely dangerous, but there's no dispute. I think if he's using drugs in his own home, I don't believe that's a danger to the community that rises to the level of him needing to be incarcerated. I think he can remain out if he fails a test. That would be a bond violation at this point because he has been on bond since, I think that would be the 29th, 28th or 29th. So if he fails the test at this point, that would conclusively prove use while on bond. And I think absolutely the court at that point would have undeniable jurisdiction to revoke his bond. I would say that I don't believe the information in front of the court at this point proves he's actually a danger to the community.
So you're arguing to me that with all, this is legitimately 4 and 5 with another one pending in Wayne County and he's still using, you're saying it doesn't show to me that he's a danger to the community?
I think if he was driving, I wouldn't absolutely not even argue that, no question. I think him failing those tests, and we don't have a pattern or anything like that. You know, we don't know if this is a one-time slip up. We don't know if he's used while he was on bond. I think the court could allow him to test today and that would solve the problem.
May I respond?
Right.
I would wholeheartedly disagree that there's no pattern. I think that the defendant having 3 previous convictions for OWI in 2002, 2004, and 2016, a 2023 Wayne County case, a 2023 Washtenaw County case, and a 2024 Washtenaw County case is absolutely a pattern. Furthermore, Your Honor, in this matter, if I recall correctly, and I think I do, but I will make sure, I believe his PAC was incredibly high. And I'm going to double check that before I get that search report. But if I recall correctly, I think in both cases, his blood alcohol content was above a 0.3.
That's correct, Your Honor.
So we are not, if this isn't a pattern, I don't know what a pattern is. People would request that the court find that the bond is an abuse of discretion and is at a higher bond remand.
I just don't think the circumstances have changed since the bond was set because and I know the court could disagree, but we don't believe there's evidence he's used since the bond was set by the magistrate, at least conclusive evidence. It's up in the air as far as he failed the test.
You keep arguing the use. The argument is, even if I give you that, the argument is I don't know that he should be out. Any use, given his record, and he's out on basically a PR, I think is an abuse of discretion. Now, if you want to argue that with me, certainly I will hear you.
Okay. I think it would not be abuse of discretion because of the length of time that has passed. So, we're already into August 2025. The positive test, we can't really deny it, but what we can say is he's not driving far. So the extreme danger to the community that comes with intoxicated driving is not present. Obviously, there's some danger to the community in hard drug use, but I believe it's less. I believe it can be managed with restrictions such as continued testing. If he fails again, he's obviously used while on bond. The court could do that. I think the court could order increased testing. You could put him on 3 times a week. I think he was on 1 time a week. I mean, the court could order testing every day if the court felt that necessary. There's a lot of options other than just incarcerating him.
What did you wish these set for?
I'm sorry?
What did you wish these set for? Preliminary examination?
No, he's going to waive.
He's waiving. All right. So at this point, what I will do is his bond is going to be changed. I'm going to set it at $25,000 cash or surety. So you're waiving your right to preliminary examination in these cases?
Sir.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them?
Yes, sir.
You understand you will not have that hearing on either one of these matters and that this will proceed to circuit court for further resolution.
Sir.
People also waive their right.
We waive, Your Honor. I do believe he previously posted $25,000.
Oh, are on both of these?
I think that's what my notes reflect, is that that's what it was set at.
I mean, I thought they were PRs.
It might be PRs, maybe $25,000 PRs, but I
There, I have each of these that they're PR.
oh, I apologize, Your Honor, my mistake. Thank you.
So people do waive
We do.
preliminary examination, haven't been waived, defendants bound over to circuit court on the single count in each case.
We will stand mute, waive the formal reading.
Defendant having waived formal reading, standing mute, court will enter not guilty plea pretrial. Custody pretrial date.
September 24th at 1:30 with Judge Fleischer.
September 24th, 2025, 1:30 before Judge Conlon in each of these matters. The bond as indicated is set in each case. It will be changed from a personal recognizance to a $25,000 cash or surety. Defendant is remanded. Yes, you may. What was that date again?
24th, Your Honor.
Court does call the case of the people versus David Davis.
This is Defender Hannah Apple appearing on behalf of Mr. Davis. Could you put you now? Mr. Davis, will you state your name for the record?
David Davis. Thank you.
Your Honor, we are asking for an adjournment, and then I did wish to address bond on behalf of Mr. Davis.
Basis for the adjournment.
The adjournment, partially as part of the bond argument, but that he can begin treatment at Dawn Farms, which he has set up to begin next week. I'm sorry, tomorrow.
Inpatient.
It is an outpatient program. He revoked his bond last week for the positive test. He is willing to acknowledge that positive test. He did contact Dawn Farms before coming to court last week, completed the initial intake, and is scheduled for his assessment to begin outpatient treatment tomorrow at noon. Based on that and his admission to the cocaine and THC use, I'm asking the court to consider reinstating his personal bond so he can attend that appointment. I did provide verification to opposing counsel last week, a letter from the treatment provider and information regarding, of course, I think based on that assessment tomorrow is going to determine what level of care he's going to be needing. But I advised him that, I'd ask the court to order that he comply with whatever they recommend, if it's regular outpatient, intensive outpatient, or even inpatient treatment. And he's willing to do just that.
I would need is there any response from the people on that?
Your Honor, this is Mr. David Davis, correct?
Yes.
Trevor Mabo for the people. When the case was called, my office had some confusion as to what his first name was and who the case that was being called. So I wanted to enter my appearance for the record. Normally, it seems we don't get in the way of release to treatment orders, but this doesn't appear to be what defense counsel is requesting. This is a felony file along with a high BAC charge where, in addition to the defendant's blood alcohol levels being north of 0.18, and also had active metabolites for THC and cocaine in his system. He was given a relatively low cash or surety bond and asked to submit to testing. And in the 3 weeks that followed his release, he was positive for both THC and cocaine in all 3 tests. And that's what was the basis for his bond revocation. I would not oppose a release to treatment, but I'm concerned about his narcotics usage if not done so.
Judge, I don't believe that statement is correct regarding the cocaine use. He had 2 positive tests for cocaine, which were shortly after his arraignment. He tested the next day, and then he did test, I think roughly about a week later, and there was a positive test for cocaine and THC. And he acknowledges that.
That powerful cocaine that's lasting a long time, like the last kid. Go ahead. I'm sorry. That was just me.
Yeah, I'm not going to make that argument for this case, but however, he did have a negative test
for cocaine. There was still THC in his system. He reports that he has stopped use. He reports that since being incarcerated, he's also made contacts to try to work out a medical marijuana card upon his release. He will not use until that card is received and provided to community corrections. If the court allows.
I get it, but
Yeah.
he shouldn't be using it all. He's got serious issues. And the very fact that he wants.
I mean, I think that's between him and his provider regarding the medical marijuana, but I think it's noteworthy that he had a negative for cocaine. He's been incarcerated for a week. He set up treatment. He has it scheduled to begin tomorrow. I would just ask, based on all of that, he is also on a scram tether. I understand the basis of part of the OWI is obviously BAC. There was no issue regarding alcohol consumption on bond. He still has a scram tether on. I don't think that that's been of any issue, and he's doing everything he can to show the court that he's compliant and willing to work that out. And he's been in custody the last week. He, I would say fairly from our conversations, has very much learned his lesson and understands if there's even the slightest slip up that he's going to be back in here and he's not going to have a chance to get out. But I would just ask for the opportunity so that he can keep his treatment appointment tomorrow that he's scheduled. And
All right, here's what I'm going to do. I'm going to need an order. I'll allow him to go to Don Farm, but prior to him going, I realize he's got a scram tether. He's going to have a GPS tether on his other leg, because if he leaves that program, doesn't cooperate in that program, he's going right back in.
Understood.
So I'll need an order.
Okay, I will prepare that today.
Thank you, Your Honor.
All right, thank you.
What is it? It's gonna put you.
You can. Hold on.
Tracking out, do all your.
And I return this out to the 25th of the month. We'll continue with that modification.
Just until I get the order to the court and they can put it out. Hopefully today.
Court calls the case of the people versus Douglas Brown. That's all I have. So I don't like the way these are put up. So what?
Douglas Brown.
Douglas Brown.
Oh, I'm sorry. He's on Zoom. My apologies. Assistant Public Defender Hannah Apple appearing on behalf of Mr. Brown. Mr. Brown, will you state your name for the record?
Douglas Brown, sorry.
Thank you.
Your Honor, we are asking the court to consider a very brief adjournment of 1 week. Mr. Brown is retaining counsel. There's been communication regarding Mr. Vincent's office, and I spoke with Amanda
Are they going to
today.
enter their appearance?
They plan to file that all today. The appearance and the substitution.
Did you talk to Mr. Vincent?
No, I talked to Amanda.
Okay, then I'll believe it.
Okay.
Thank you.
You just need a week?
That's it.
What did, so you, my condolences to your family, first of all. And secondly, though, you guys sent him here alone last week. So I don't know what?
As you can understand why I had to.
No, I understand why, but yeah, I don't know what, I can't remember what he did.
I'm sure he messed it up.
Oh, he did, but I just don't know what date.
We do have a matter in front of you next week on the 18th. So it most likely was that.
That was, so just so you know what he said. Just so you know what he said. He walks in and I said, "You're here alone." He said, "Yeah." I said, "Okay, so what dates did they give you?" He said, "They just said set any date." I don't think that's what you said. That's okay. But if,
And that's how I know that you know me, Your Honor.
yes, I know. You would have given him a date and he would have, well, anyway. All right, I will on this one, if it's gonna retain, then I'll adjourn it out 1 week.
Thank you, Judge.
Go with the other 135. September 18, 2025, 9 a.m. bond continued. All right. Thank you, Mr. Douglas. Court calls the case, people versus Ishmael Davis.
Assistant Public Defender Dodgy Leave on behalf of Mr. Davis, who is approaching.
Good name, sir.
Ishmael Alexander Davis.
Thank you.
And Your Honor, I do have a green sheet, or I will be retrieving one in a moment, but we're going to be requesting an adjournment in order to continue negotiations. We're hoping to wrap some additional cases into a global resolution in this matter.
September 25th, 2025, 9 a.m. File and continue. Court calls the case of the people versus Elia Bellows.
Trevor Maple on behalf of the
Yes, I thought. Counsel approach, please. Counsel, at this point, I am not going to recuse. I would handle anything. Will not be handling if this matter is set for preliminary examination. I will not be handling it. I would not do that. And if it comes to anything where a decision has to be made, I would refer it to a different judge. But as long as it's going on, I understand there's no objection to the court proceeding.
That is correct, Your Honor. I think that is what we discussed.
The defense is okay with everything the court just put on the record. Thank you.
All right, very good. And so you'd like an adjournment of these proceedings. So I will grant the adjournment. I will set probable cause conference in this matter for September 25th, 2025. All right.
Okay.
Bound continued. Thank you.
Come back and call you.
Court does call the case of people versus Robin Lee Finney.
Trevor Maple for the people.
Assistant Public Defender Hannah Apple, standing in for Ms. Perny on behalf of Ms. Finney, who's approaching now. Your Honor, we are asking for a release to, or an adjournment. I believe the court already signed a release to treatment for Ms. Finney. Okay. So we're asking for an adjournment for that to be conducted. If she completes treatment, my understanding there's a resolution that will be offered.
But is that treatment already set up, or have I just ordered it and it hasn't been accomplished?
I have. I did my access call yesterday to Bear River, Your Honor, and we've already been accepted.
So they're setting, so the jail is setting you up so that you can go to Bear River.
Correct.
Okay.
Then I just had to do it updated, sir.
Did they give you a time frame on anything?
Today I finished my call to talk directly with Bear River as far as with them, like, they just want to go over a couple of things and then we're just waiting on transport.
Got it.
Thank you, Your Honor.
Let's do this. Just so that we can keep track. I don't want to go out to October 9th, but I want to give time in case there's transport. She may not be able to communicate directly with anyone immediately. So I'll adjourn probable cause out to September 30th.
Okay. As soon as you get their call.
2025, 9 a.m. That's on a Tuesday.
Correct.
And we can take a look at that. All right.
Thank you, Your Honor.
If I don't see you before you go, good luck.
Thank you, Your Honor. Thank you.
Court does call the case, people versus Robert Roulette. Alex, he's in custody. In Zoom.
Assistant Public Defender Hannah Apple again on behalf of Mr. Roulette, standing in for Ms. Perny.
Yeah, but I don't.
My name is Robert Gallant, also known as Lynn.
Oh,
Oh,
Miss
right.
Flood. My
Got it. Okay. I see the way they put the name.
No
Different.
problem.
All right. What are we doing?
Your Honor, it appears we are asking for an adjournment.
Is Mr. Killowald here?
He was.
Outside of PD student room.
I believe I also, Mr. Killowald did sign, I don't know if the court's in receipt of this, I'm sorry. A release to treatment. Mr. Killowald also signed off on as part of the request,
All right.
making this request. And then looks like Miss Douglas and Miss Parney. The court does not have this yet. I'm sorry.
All right. Do you have any problem with the public defender standing in for the purposes of this hearing for Mr. Killowald?
Oh, no, no problem, sir. Everything's good. You go.
Okay, thank you.
No problem.
Yes, so I believe it discusses on there that there's we're trying to secure some housing as well. So release to treatment in the.
And there was an order submitted. And let me give this to you, let you process that. Yeah, to go into the file. Okay. All right. So you want an adjournment on these, the 30th?
Please. Sounds good.
And just to make sure, all right. Probable cause conference in these matters will be adjourned to the September 30th, 2025, 9 a.m. Bond will continue on this. All right, thank you.
Thank you, sir. Did you sign the request for treatment, sir? We're able to.
For the treatment?
Yes, sir.
Yes, I'm going to sign that. I'm just
Thank
having
you
my
so
staff
much, sir.
process everything. Yep.
Yes, sir. I
Okay.
appreciate your help. Thank you so much.
Thank you. Court does call the case People versus April Black.
Stephanie Cannon on behalf of Ms. Black, who is approaching.
April Black.
All right. Court has before the plea form. Is that what we're doing?
Yes, Your Honor.
All right. Plea form indicates that the defendant will be pleading guilty to the charge of disorderly person jostling as a count 3. On a successful plea to that charge, counts 1 and 2 would be dismissed. Defendant is agreeing to pay restitution for damage to the police car.
Yes, Your Honor, that is correct.
And also that the prosecutor will recommend prosecutors defer. That's the court's full understanding. Is that it?
Your Honor, that is my complete and full understanding of the agreement.
May I have her sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony about the whole truth and nothing but the truth of the
April Black.
Ma'am, it is this court's understanding that you're going to plead guilty to the charge of disorderly person jostling. That is a misdemeanor punishable by up to 90 days in jail, $500 fine plus court costs. Do you understand that?
So we said.
Yes.
All right. You also understand, ma'am, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington, 14B District Court. You want to talk to her or you want me to?
No, Your Honor, she asked me who was Judge Washington. I was just.
Oh, who was Judge?
Yeah.
Really?
Yeah,
What'd you say?
I said that Judge
Tell
Washington
her.
is just an imaginative, wonderful person, and she should be happy to be sentenced in front of her.
You like her better than me, Cannon?
You don't.
Stop asking.
Sure. Your Honor, you
Never
both
mind.
have
I'm
such
not gonna
great
take-
attributes.
All
of
right.
strength.
You understand that you'll be sentenced before Judge Washington.
Yes.
All right. Understanding all of that, do you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
Please look at paragraph 5 on that form. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights contained on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
of your own free will
Yes.
and because you believe that you are indeed guilty of this offense?
Yes.
on the date of June 22nd, 2025, at the location of Alston Court in Ypsilanti Township, Washtenaw County, state of Michigan. What do you do on that date that makes you think that you're guilty?
I pushed a cop.
You did what?
I pushed a cop.
A cop?
Yes,
Police officer?
yes,
You pushed them?
yes,
And that was in public?
yes,
And did that create a disturbance or
yes.
when you did that? I'm sure it did. All right. Ma'am, I do have to advise you, if I accept your plea, between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined in the Michigan court rules, that any sentence recommendation or evaluation the court would no longer be bound by, and you would not be able to set aside your plea. You understand that?
Yes.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
Your Honor, the defense is not.
No, Your Honor.
And have I complied with the court rule? Would it be proper to accept the defendant's plea?
Yes, Your Honor.
It would, Your Honor.
Court will accept the defendant's plea guilty to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this matter will be
October 16th at 10 a.m.
October 16th, 2025, 10 a.m. before Judge Washington.
Thank you so much, Your Honor.
Bond will continue. Thank you.
Oh, Your Honor, can we address bond? My apologies. I'll go as quickly as possible. As the court is well aware, my client has been untethered during this whole time
I'm
frame.
going to leave that up to Judge Washington after her assessment.
Thank you, Your Honor.
Thank you. Let's call the case of the people versus Alua Gillis.
Alexander on behalf of the people.
Assistant Public Defender Chelsea Vergil with and on behalf of Alua Gillis. Please state your name.
Alua Gillis.
What are we doing?
Your Honor, we are asking for an adjournment after Ms. Gillis has been found competent, just to continue a plea discussion, and I would ask to address bond.
Just count here.
Yes. So Your Honor, the court received the count.
Yes, I do see it. I think she is competent to stand trial. All right. No other evidence
No, Your Honor.
from others
No, Your Honor.
stipulate to the report. The court, based upon that report, would find that the defendant is competent to stand trial, would specifically indicate the defendant can understand the nature and objects of the proceedings against her and can rationally assist in her defense. Therefore, the defendant is deemed competent. All right, I'll need an order presented to the court.
Yes, Your Honor.
All right, you're asking for this to be set for PCC.
Yes.
Set a probable cause conference in this case for September 25th, 2025, 9 a.m. Bond continue.
Can I address bond?
Certainly.
She is being held on another matter, so I'm asking for a low cash bond so that once those matters are resolved, she could potentially get out of custody. Once out of custody, she plans to live she lives in Ypsilanti. She lives very close to her parents.
When's the next hearing on the other matter?
It's Wednesday, September 17th. And then I have October 22nd.
And Your Honor, I'm not sure of the other matter. She is her bond is denied. She has a VOP hold for stalking victim right now.
I didn't think her bond was denied. I thought it was 20,000.
It is 20,000.
She is being held on other matters, though, Your Honor.
A VOP?
Correct. She pled two different stalking cases this year.
And I don't know why I'm hearing bond on this one, but go ahead, counsel.
I believe that the alleged violation would be this case. However, she does out of custody do outpatient treatment with CMH. Again, she lives near her parents who are supportive, make sure she gets that treatment. She's at risk of losing her disability benefits, so she'd really like to be out of custody. We have no objection to a GPS tether.
Your Honor, I just wanted to put on the record that she is on probation for stalking the same victim, and this violation is her continuing to stalk the victim. She's had all these things put in place with probation.
Motion for bond reduction is denied. Bond will continue. Thank you. Court does call the case of the people versus Jay Dingman.
And for that, for the people.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Dingman, who does appear via Zoom from Washington County Jail, Your Honor. Sir, can you please state your name for the court?
Jay Hoan Dingman.
Thank you. Your Honor, I'm respectfully requesting an adjournment. I'm asking if the court would consider possibly 1 week. I did receive an offer from the people.
I don't like these 1 week adjournments. I'm just letting you know.
I understand,
So
Your
it better
Honor.
be all taken care of. I'll adjourn it out 1 week,
He
September
refused-
18th, 2025, 9 a.m. Bond continues.
Thank you, Your Honor.
Court calls the case of the people versus Adam Harris.
Alexander, on behalf of the people. Assistant Public Defender Hannah Apple, appearing on behalf of
Mr. Harris, standing in for Mr. Kearney on this case. Mr. Harris, when you are approaching, state your name.
Adam Harris.
Thank you. Your Honor, we are asking that this matter be set for preliminary exam.
All discovery is complete.
To our knowledge, yes.
People have their witnesses available the 23rd.
We'll do our best, Your Honor.
Preliminary examination in person, September 23rd, 2025, 9 a.m. That's before Judge Barr. Bound will continue.
All right, thank you, Judge.
Court does call the case, people versus Charles Blakely.
Raymond Cook to the people.
Stephanie Cannon, on behalf of Mr. Blakely, who's appearing to my right, please state your name for the record.
Charles.
Mr. Blakely, you indicated that you do have a hearing problem. Do you need anything from the court to hear better?
I don't think so.
Okay.
Thank you. You're good? I think okay.
Your Honor, we are requesting adjournment of this matter for meaningful consultation between the client.
Probable cause conference will be set September 25th, 2025, 9 a.m. Sorry.
Thank you, Your Honor.
Thank you. Court calls case of the people versus Roman Hop.
Assistant Public Defender Hannah Apple, appearing on behalf of Mr. Hawk, who's approaching now.
Mr. Hop, will you state your name for the record?
Ramon Hunt.
Thank you. Your Honor, we're asking that this matter be set for preliminary exam.
Discovery is complete.
Yes, Judge.
People have their witnesses available the 23rd.
We'll try, Your Honor.
Preliminary examination in person, September 23rd, 2025, 9 a.m. before Judge Fleischer.
Thank you, Your Honor.
Bound continue.
Thank you.
Court calls the case of the people versus Jamie Burke.
Trevor made most of the people.
Did I not have an assignment on this?
No.
What's no mean? Did I?
No assignment. Oh.
This was a PD case.
Yes.
There was no assignment.
Assistant Public Defender Hannah Apple, appearing on behalf of Mr. Burke. That is correct, however, or Mr. Burke, we see your name for the record.
Yes, Jamie Burke.
Thank you.
Hello, Your Honor. Good
Hello.
morning to you.
Your Honor, we're asking for an adjournment. There's some restitution payments that he needs to begin making before there will be any consideration for a resolution.
No objection, Your Honor.
I have absolutely zero objection to that either. Just gotta give me 2 weeks to make a decent payment because I just started a job. If you can understand that.
Probable cause, September 30th. That's a Tuesday, 2025, 9 a.m. Bound continue.
Thank you, Your Honor.
Thank you.
Really appreciate it.
Thank you.
I hope you have a wonderful day.
You do the same.
Absolutely.
Thank you.
Thank you.
Court calls the cases of the people versus Kyle Humphreys. All 6 cases.
Assistant Public Defender Ben Dunaway on behalf of Mr. Humphreys, who stands to my right. State your name for the record, please, sir.
Kyle Brenton Humphreys.
Thank you.
Your Honor, this is a date and time for a PCC. Mr. Humphreys would like to request exam on all matters, and we would like to address bond.
All discovery is complete on all these cases.
Yes, Your Honor.
People have their witnesses available on the 23rd. Preliminary examination in person will be set September 23rd, 2025, 9 a.m. All of these matters will be before Judge Barr. As the bond.
Your Honor, on August 28th, my client turned himself in to the police station. He advised the police that he thought he had a warrant and he had been committing some crimes around town to support his drug habit. My client, my client has a single prior conviction for nonviolent retail fraud in the second degree, nothing
So
else.
aren't part of these cases bond violations for his other cases?
Are they what? Sorry.
Aren't some of these cases bond violations on the other cases?
I think some of them are, I know one of them dates back. I did charge these cases. But I have to check the date of offense, right?
I think they might be probation violations on his retail fraud in Wayne County, but I don't think it's a bond violation.
I've got complaints for conditional release on this defendant. Go ahead with your argument.
Your Honor, he has no violent charges. He has no violent convictions. We believe his guidelines are 0 to 11. He did turn himself in. He's been fairly forthcoming. We'd ask the court to release him to treatment.
I will sign a release him to inpatient treatment.
Okay.
It's not an issue.
That's all we're asking for, Your Honor. Thank you.
Well, should have led with that. All right, we'll sign. If I have an order, I'll do it.
Thank you.
All right.
Thank you. I will submit the order to the clerk of the court.
Court calls the case of the people versus Derek Stewart.
Your Honor, Raymond Cook of the people.
Assistant Public Defender Hannah Apple, hearing on behalf of Stewart, sitting in for Ms. Perry. Mr. Stewart, will you state your name for the record?
Mr. Derek Stewart.
Thank you, sir.
Your Honor, we are asking for an adjournment. My information is that we do not have a competency report received.
I asked for a bond, You're not the same attorney I had the other day. We were asking for a PR bond. Hello?
Your Honor, if you could give me one moment to check the file regarding the bond request, please. Thank you.
We were discussing a bond Tuesday. You're not the same attorney I had Tuesday.
One moment, Mr. Stewart. Your attorney had to leave court.
It's 4/24/25. I denied the bond request. Then did he disappear? No, and I had a competency. I have a competency. And then he didn't appear. His bond was denied.
I didn't appear. What you mean I didn't appear? I was in jail.
Well, he had a bond violation. His bond was denied.
But they said you couldn't go ahead with the bond violation until the competence.
Sir?
Your Honor,
Go ahead.
I believe the information you say is correct in regarding the bond request. Mr. Stewart is asking the court to consider a release on a personal bond. He reports that he would stay at the Delana Center if released. We do have updated contact information. He has been in custody over 100 days.
Probable cause conference, September 25th, 2025, 9 a.m. Motion for bond reduction is denied. Bond will continue. Court does call the case, People versus Jason Campbell.
Are you ready to go to the people?
Sorry, Stephanie Kane on behalf of Mr. Campbell.
Sorry to wake you.
My apologies, Your Honor. Your Honor, on behalf of, but clearly not with, we have attempted to reach out to Mr. Campbell to no avail. I'd ask for an adjournment.
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $10,000 cash surety. That warrant will issue immediately.
Thank you, Your Honor.
Court does call the case of the people versus Mark Jackson.
Good morning, Your Honor. Assistant Public Defender Alexis Zerbst with and on behalf of Mr. Jackson, who is approaching. Can you please state your name for the record?
Mark Jackson. All right, I have before me a plea form that indicates that the defendant will be pleading no contest to the charge of attempted possession of a loaded firearm in a vehicle. That is a misdemeanor punishable by up to 1 year incarceration, a $1,250 fine plus court costs and mandatory forfeiture of the device. Upon a successful plea to that charge, count one would be dismissed. That is the court's full understanding of the agreement.
That's accurate, Your Honor.
That's correct, Your Honor.
May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name.
Mark Jackson. Sir, it is this court's understanding that you are going to be pleading no contest to the charge of attempted possession of a loaded firearm in a motor vehicle. It's a misdemeanor punishable by up to 1 year incarceration, a $1,250 fine plus court cost, and mandatory forfeiture of the weapon or device. You understand that, sir? Yes. You do understand what a no contest plea is? Yes. All right, two things about it I have to make sure that you understand. The first thing is that it means that you're not further desirous or wanting to contest this charge. You understand that? Yes. Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that? Yes. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge and you'd sentence before Judge Washington in the 14B District Court. You understand that? Basis for the no contest plea?
Lack of recollection, Your Honor.
All right. Sir, to that charge, how do you plead? No contest. Now, you understand that by pleading no contest, you'll not have a trial of any kind? Yes. You signed an advice of rights form, is that correct? Yes. Any question regarding any of those rights? No. Please look at paragraph 5. You'll see a copy on the podium. Those rights which are part of a trial. You understand by pleading no contest, you're giving up those rights as well as all the rights on that form? Yes. You understand you're giving up your right to appeal of right? Yes. You on probation or parole? No. Has anybody promised you anything other than what's been stated on the record to get you to plead? Anybody threaten you or coerce? No. You're doing this voluntarily? Yes. Of your own free will? Yes. All right. Court has been provided and has reviewed Washtenaw County Sheriff's report for their case number 22-84676. Any objection to the court having reviewed that report?
No objection, Your Honor.
Based upon a review of that report, the court would find that there's sufficient factual basis in which the court could determine the defendant's guilt of this offense. Sir, I do have to advise you that if between the time I accept your plea and the time of sentencing, you commit misconduct as defined under the Michigan court rules, you would not be entitled to, or the court would no longer be bound by any sentence evaluation or recommendation. You understand that? Yes. You also understand that you would not be entitled to withdraw your plea? Yes. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
Have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, sir.
Defense is satisfied, Your Honor.
Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. A pre-sentence investigation and report is ordered at 14B. Probation sentencing in this matter will be
October 9th at 10 a.m.
October 9, 2025, 10 a.m.
Your Honor, if we may
for
briefly address bond when appropriate.
Judge Washington briefly, and hopefully it's relevant to everything. Go ahead.
Your Honor, we would be asking for his release on a GPS tether. I believe Mr. Jackson entering a no contest plea shows he's serious about this case and ready to get this taken care of. I know there were some previous issues because of his incarceration in Georgia. However, he does have family support. Mr. Jackson's father is present in the courtroom. That will be another safeguard to make sure that he stays accountable and takes care of this case. He also does have a job lined up as well. He was working prior to coming into custody today.
That I heard.
Yes, Your Honor, but I believe that the different circumstances today is that he's admitting responsibility by pleading no contest.
Your Honor, I'm not opposing to listen to GPS tether.
Wow. All conditions will remain in effect. Defendant may be released on a $10,000 personal recognizance bond. with the GPS tether prior location tracking prior to release.
Thank you, Your Honor.
Yeah. Court does call the case People versus Michelle Campbell.
Morning, Your Honor. Raymond Cook to the question.
Brian Bowling on behalf of Ms. Campbell, Your Honor. Ms. Campbell? She's not here.
That didn't happen, huh? Okay.
Your Honor, I wasn't able to get in touch with her. I'd ask you to adjourn it. Give me that consideration.
Bench warrant, 10,000 cash surety. That warrant will issue immediately.
Thanks, Judge.
Does call the case of the People versus Gerald McKinney.
Assistant Public Defender Chelsea Vergil with and on behalf of Gerald McKinney. Mr. McKinney, please state your name.
Gerald McKinney.
Can you stand here?
What are we doing?
I want, request for the payment.
I'm sorry, Your Honor.
Walmart.
We are,
And Pontiac Trail.
I'm sorry. It's come to light. I believe there is further discovery issues. I thought we were ready to proceed to exam. However, I'm asking to adjourn now for further discovery.
Probable cause conference, September 25th, 2025, 9 a.m. I'll need a green sheet. Continue.
Thank you, Your Honor.
Court does call the case People versus Marquetta Clemens. Wait, why are these writing?
Assistant Public Defender Natalie Pate for Ms. Clements, who I do not believe is present, Your Honor. I do not have an explanation for her failure to appear outside of the fact that the only contact information I have for her, unfortunately, is a mailing address. For the record, I would request an adjournment.
This warrant will issue for defendant's failure to appear upon this set amount of $10,000 cash surety. That warrant will issue. Court calls case of the People versus Maxwell Nowak.
Raymond Cook to the People.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Nowak, who stands to my right, please state your name for the record, sir.
Maxwell Nowak.
Maybe approach.
Briefly.
Recording stopped.
Adjournment on this.
Yes, Your Honor. I have to now because we do not have discovery, and I found out yesterday the reason why was because this motion was filed, which I do stipulate to the protective order, Your Honor. However, my client has been sitting a week after we requested discovery before this motion was filed. I've been unable to review any discovery with him.
If
So
the
we do
whole
need to
issue
adjourn.
was just the personally identifiable information, you guys were at the bench just talking about that with me. I don't know why I needed to be part of that conversation. You guys should be able to work it out. Just
I
talk
agree,
to
Your
each
Honor.
other.
I agree.
I'll adjourn it out 2 weeks. Probable cause conference will be adjourned September 25th, 2025, 9 a.m. Bound continue. Thank you.
Thank you, Your Honor.
Court calls the case of the People versus Carlton Cross.
Assistant Public Defender Natalie Pate on behalf of Mr. Cross, Your Honor, who I do not believe is present. I do have an update. I did speak with Ms. Stewart with Jail Services, who indicated that although he did have a release to inpatient treatment, I cannot represent to the court that's where he was released. He posted his bond on August 29th. He did sign an ROI with Sacred Heart. I did contact them and leave a voicemail asking for confirmation of his presence there. I did also leave a voicemail at his personal number. However, unfortunately, did not hear back. And for the record, do not know where he is and would respectfully request an adjournment.
Bench warrant will issue bond 10,000 cash surety. And warrant will issue immediately. That's in both matters.
Thank you, Your Honor.
Court does call the case of the people versus Enda Nielsen Osorio Martinez.
Assistant Public Defender Chelsea Beals with and on behalf of Nelson Osorio Martinez. Please state your name.
Hello, my name is Eddie Nelson Manrique Osorio Martinez.
We are asking to adjourn on this case. Unfortunately, I was unable to meet with my client.
September 25th, 2025, 9 a.m. Bond continued.
Okay.
Didn't hear. I don't know.
Court calls the case of the people versus Malik Xavius. Cleveland. Yeah, that's not what they, okay, gotcha. Malik Cleveland. I'm sorry.
Stephanie Cannon on behalf of Mr. Cleveland. Mr. Cleveland, could you please state your name for the record?
Malik Cleveland.
And Your Honor, we are going to be requesting an adjournment of this matter. Plus, I have a stipulated order in agreement to allow my client to travel. I'm presenting both to the court.
Where?
Your Honor, he has a prepaid cruise to Mexico set up. Prepaid, he's already paid for the cruise to Mexico.
I know what prepaid means.
My apologies.
Really?
Hey, Judge. How can I help you, Your Honor?
Just about done with you. Well, when is he going to Mexico?
He goes in October 13th, I believe, and comes back on October 18th.
Correct. Probable cause conference will be adjourned to September 30th, 2025, 9 a.m. Bond continued.
And Your Honor, did you know I had the order already for you, Judge? For you? No? Okay.
I guess you wanted to thank you. Thank you for doing your job. All right, court calls the case, people versus Vandalist Patterson.
And then on behalf of people.
Assistant Public Defender Chelsea Beals with and on behalf of Landis Patterson. Who approaches. Mr. Patterson, please state your name.
Landis Patterson.
We are asking to adjourn for a mitigation report that should be coming in soon.
Pardon?
It should be done soon.
September 25th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Court calls the case of the people versus Quan Patterson.
Assistant Public Defender Don B. Lebo, Mr. Patterson.
Your name, sir? Quan Patterson. Thank you.
And Your Honor, with the state requesting to set this matter for preliminary examination, please.
Is all discovery complete?
To my knowledge, Your Honor.
People have their witnesses available the 23rd. Preliminary examination in person, September 23rd, 2025, 9 a.m. That's before Judge Fleischer.
Thank you, Your Honor.
Thank you. Bond continued. Court calls case of the people versus William Riddle.
Assistant Public Defender Chelsea Beals with and on behalf of William Riddle. Mr. Riddle, please state your name.
William Michael Riddle.
Your Honor, we are asking to adjourn for a continued plea discussion, and I would ask to address bond.
Probable cause conference, September 25th, 2025, 9 a.m. as to bond.
Your Honor, I believe this is the only thing holding Mr. Riddle. He does have a plan of a place to stay in Ann Arbor with a coworker. He was previously employed and he has communicated with his boss so that he can return to employment. He plans to continue going to NA and AA meetings. And we have no objection to a GPS tether. I ask you to consider a personal bond.
Response.
Object to any modification of bond. This is a very serious case. In this case, we originally requested a $15,000 cash surety bond. We were given a $15,000. In this case, he wanted the victim out of nowhere, grabbed her by the throat and strangled her until she was unconscious on the ground. She also informed officers he had strangled her 2 weeks prior. This incident was witnessed by someone who saw him strangle her to the point where she was limp and lying on the ground. When officers arrived, he was trying to help her back up. She had marks on her neck and had a sore throat, and her skin was warm to the touch. I mean, I have concerns given the facts of this case that she was strangled to the point of unconsciousness. Also, the fact that it was witnessed by someone. And he does have a history of retail frauds, motivated second, CSC second, larceny, controlled substance use. He does have 2 holds, one out of Ingham County for collections and another for retail fraud, 3rd out of Jackson. So at this point, I would be asking for our original request of $15,000 without the 10%, or that bond remain as set.
I don't want to get into arguing about the facts, but he does certainly dispute them. Regarding the holds, he has already spoken with Jackson County, I believe. In both cases, he just owes a couple $100. I think that staying away from the complaining witness is sufficient to ensure the court that no further trouble will be had in this case. I don't expect any bond violations. While he does have a criminal history, I don't think that anything of this nature is within his criminal history. And he does have a plan for a stable lifestyle. So I ask again the court to consider a personal bond.
Motion for bond reduction is denied. I won't up the bond or send it to the cash or surety, but I'm denying his request to change the bond. Thank you. Court does call the case People versus Abdul Scott.
That's both the people.
Public Defender Natalie Pate with and on behalf of Mr. Scott in both cases, who is approaching. Please state your name for the record, sir.
Abdul Scott.
Thank you.
Thank you, Your Honor. I have discussed both matters with my client as well as the people. To my understanding, discovery is complete. We are asking to set for exam, please.
People have their witnesses available the 23rd.
Correct that, Your Honor.
Preliminary examination in person, September 23rd, 2025. 9 a.m. before Judge Barr on both matters. Court does call the cases of People versus Man Davis.
That's all just for the piece.
Your Honor, Assistant Public Defender Ben Dunn with my client, I believe, just went to the bathroom. Could we pass this matter?
All 4 of them? Yes, I'll pass. What?
Should be walking in any moment. He was in the room.
Ben Davis?
No. This time.
Good afternoon, Your Honor. Edward Lucas on behalf of Man Davis in 1167 and 1367. I'm dropping on the door. You didn't want my.
No, you're good. I'm just
Lost Lauren. We lost Lauren. He's around here.
Mr. Brown's assigned. Oh, Brown.
He lost.
Lauren.
Yes.
No, he only know 22 separate.
I think
no district.
I think it's his birthday. So he's like older now. He's moving slow. Make sure to tell him that. Where is he?
I'll check in the office, Your Honor.
Okay, we're gonna lose you now.
I do know that I've talked to Lauren and they were also seeking an adjournment.
And what are we doing?
Adjourn.
Oh, all right.
Brian Bowling for the PD's office, Your Honor.
All right, you're seeking an adjournment.
That's correct.
How much time are you looking for?
2 weeks.
2 weeks. Probable cause conference in these cases will be adjourned to September 25th, 2025. Any found people.
That's all. Yeah, thank you, Your Honor.
Thank you.
Thanks, Judge.
Thank you, Mr. Davis. Court calls case People versus Elizabeth Hill.
Trevor Mabo, for the people, Your Honor.
And good afternoon again. Edward Lucas on behalf of Elizabeth Hill is approaching.
Elizabeth Hill.
Thank you. She's waving his hand.
Waiving her right.
Ma'am, is that correct?
Yes,
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed.
yes,
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
yes,
People also waive their right.
Yes, sir.
Preliminary examination having been waived, defendant is bound over to circuit court on count 1 with 2 following.
Thank you. Your Honor, we acknowledge receipt of the information, stand mute, waive its reading.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea as to both counts. Pretrial in this matter will be set for
November 4th, at 1:30.
November 4th, 2025, 1:30, Judge.
Thank you, Your Honor.
Thank you. Bond continue. Case of the people versus Marcus Earl, 2 cases.
Good afternoon, Your Honor. Nathan Cook for the people.
And good afternoon, Your Honor. Brendan Dvorsky appearing on behalf of Marcus Earl. Your Honor, as you can see, my client is not present. As it relates to at least one of the cases, Your Honor, that being 25 F5 5525-FY, that's the one I'm representing Mr. Earl on. Today was a review date for the competency. I was before Your Honor back on, it looks like June 12th of this year. At that time, I had referred my client for competency. It was for Zoom at that point in time. I had a very difficult time communicating with my client. It has not improved at all, Your Honor. I haven't been in touch with him since that date. I've spoken to his mother numerous times. I know that I had actually emailed her the order that was sent to my office from the forensic center about the appointment at the forensic center on August 8th, 2025. It's my understanding that he never participated in that interview. I cannot get him to communicate with me. She said that he will not attend voluntarily. At this point in time, Your Honor, I'm going to defer to you to determine what the best course of action moving forward.
Best I can do is just issue a bench warrant.
Okay, I'll let
bond is set in the amount of $25,000 cash surety. That warrant will issue immediately. And just so that you know, and you can let the defendant know that he also has another case pending that he's not yet been arraigned on.
I absolutely will, Your Honor. Thank you.
All right.
Have a good day.
Court calls the cases of the people versus Edward Harris.
And then on behalf of the people.
Stephanie Cannon on behalf of Mr. Harris, as it relates to case number ending in 1287.
Good afternoon, Your Honor. Jonathan Sachs for Edward Harris, case number ending in 1250.
All right.
Your Honor, despite my best efforts of reaching out to him multiple times, I have not had any communications with my client. I'm asking for an adjournment.
Exactly the same, Your Honor. I'm hopeful he's doing something exceptional today and we'll be here next time.
Request a bench warrant.
Bench warrants will issue for the defendant's failure to appear in both of matters. Bond in each case will be set in the amount of $10,000 cash surety. Those warrants will issue immediately.
Thank you, Your Honor.
Thank you. Case of the people versus Terry Lanier.
Good afternoon, Your Honor. Jonathan Sachs for Mr. Lanier.
Terry Lanier, thank you. You're requesting an adjournment.
I am, Your Honor. I was assigned yesterday for Mr. Lanier, and it was good to meet him today, but I still need to receive and review the rest of discovery and spend some time talking to Mr. Lanier.
Nothing to add, Your Honor. I believe discovery had been completed prior to the new appointment, but I'll work with Mr. Sachs to make sure they have everything.
September 25th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Court calls the cases of the people versus Todd Reber.
Different others from people.
Robert, on behalf of Mr. Weberg.
Public Defender Natalie Pate standing in for Public Defender Lauren Perny on behalf of Mr. Reedberg in the cases ending in 0694, 0793, 0906, 0718, and 0891.
Your Honor, Mr. Reberg was previously released to treatment. It's my understanding that he is currently inpatient at Sacred Heart in Richmond, Michigan. The facility has not brought him forward today. We are working.
Is he there?
If I may, Your Honor, so Miss Perny reached out to Sacred Heart and left voicemails and did not hear back from any sort of human, but we do understand that he was released to treatment on the 3rd, but we do not have confirmation of that he is still there. But for the record, we'd request an adjournment. I cannot represent where he is.
Bench warrant will issue on these cases for defendant's failure to appear, bond 10,000 cash surety. I will allow you at least some time to try to get some verification if he is in treatment. I won't have those warrants issue until September 16, 2025.
Thank you very much, Your Honor.
Thank you.
Thank you, Judge.
Court calls the case of the people versus Brandon Davis.
Trevor may vote for the people, Your Honor.
Did you appear? Yes. Assistant Public Defender Ben Denowith on behalf of Mr. Davis, who stands to my right. Would you state your name for the record, sir?
Brandon Hezekiah Davis.
He's waiving.
Yes, Your Honor.
Sir, you're waiving your right to a preliminary examination?
Yes, sir.
You understand that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, Judge.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right.
Yes, sir.
Preliminary examination having been waived, defendant is bound over to circuit court on a single count.
Able to stand mute, waive the formal reading.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial in this matter will be set for
November 5th at 1:30 with Judge Conlon.
November 5th, 2025, 1:30 before Judge Conlon.
Thank you, Judge.
Bond continued.
Your Honor,
You want on bond?
no, just on the matters being called. We did call both of his case numbers, correct?
Mr. Davis?
Yes. Brandon Davis?
Do we have two Brandon Davis?
Both numbers are on the waiver form.
Yes, they're both, yes. So he's bound over on count one. They weren't banded together.
Thank you for the clarification.
Yeah, no, thank you for clearing that up because his other file is there. He's waiting on that one also.
Yes, Your Honor.
All right.
And I did want to clarify for the record that I had extended an offer to Mr. Davis that in exchange for a waiver, the people would not be filing a habitual offender notice against him in either file. He is going habitual 4, I believe, and so we're foregoing that. And I wanted to state that fact.
All right.
Thank you.
Thank you. All right, the other case also will be on that time before Judge Conlon. All right. Thank you. Court calls case of the people versus Antonio Guyton.
Trevor Mayville for the people, Your Honor.
Assistant Public Defender Alexis Upson on behalf of Mr. Guyton.
Your name, sir?
Antonio Guyton.
Thank you. You're requesting an adjournment.
Yes, Your Honor.
Cause conference, September 25th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court calls case of the people versus Shaquanda Hall.
Public Defender Ben Denowith on behalf of Ms. Hall, who should be on Zoom.
Here.
Ms. Hall?
Yes, I'm here.
All right, you need a camera.
It's on.
No, it's not.
Okay, hold on. I'm trying. Okay. Okay.
Thank you.
Your Honor, we would like an exam date, please.
Discovery is complete.
Yes, Your Honor.
People have their witnesses available the 23rd.
Yes, Your Honor.
Preliminary examination in person, September 23rd, 2025. What?
She was previously from a judge bar.
That's it, Bar. Yes. 9 a.m. before Judge Bar.
Thank you, Judge.
On continue. Court calls case of the people versus Jessica Hess.
Stephanie Cannon on behalf of Ms. Hess. Ms. Hess has been appearing by Zoom. Is she currently there, Your Honor? Maybe? No. Okay. Then, Your Honor, at this time, we have reached out to my client. I even texted her. I have not heard from her. I would be asking for an adjournment.
Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $10,000. Cash surety. That warrant will issue immediately.
Thank you, Your Honor.
Thank you. Court does call the case people versus Marcus Jones.
Josh calls for the people.
Your Honor, Assistant Public Defender Natalie Pate stepping in for Ms. Perry on behalf of Ms. Jones or Mr. Jones. He is here, Your Honor. I just spoke with him in the hallway. Would you mind if I could go see if he's still out there or maybe in the bathroom? Or Ms. Cannon will grab him.
You're sending Cannon?
Yes.
Okay, I'll pass it.
Thank you very much,
It'll
Your
be a
Honor.
minute. Court calls the case people versus Jocelyn Mathis.
An Assistant Public Defender Natalie Pate with and on behalf of Ms. Mathis, who is present, not in the hallway. Could you please state your name for the record, ma'am?
Jocelyn Mathis.
Thank you, Your Honor. To my understanding, discovery is complete and I have reviewed it with my client. We're asking to set it for a preliminary examination at this time.
People have their witnesses available the 23rd.
Yes, sir.
Preliminary examination, September 23rd, 2025, 9 a.m. That is before Judge Fleischer. Continue.
Thank you, Your Honor.
Thank you. Court calls the case of the people versus Kevin McCullough.
Josh calls for the people.
Brian Bowling on behalf of Mr. McCullough. I'm hoping might be on Zoom.
He's not.
Your Honor, from all indications that I have, Mr. McCullough is at Bear River. Unfortunately, I was unable to get in touch with him to speak with him to confirm that, but that's my understanding. It is also my understanding there is a community corrections bench warrant outstanding on the matter already.
Yeah.
A prior hearing.
Well, I'll give you time to try to figure that out. I'll adjourn the probable cause conference because I also have the sheet from acknowledging admission. So it'll be September 30th, 2025 at 9.
Wonderful. Thank you, Your Honor.
Continue. Or the bench warrant outstanding. Court does call the case people versus Nathan McCullough. What is it? You got Joe.
And on behalf of the people.
Assistant Public Defender Alexis Zerbs with and on behalf of Mr. McMullen, who is approaching. Once you get to the podium, please state your name for the record.
Nathan McMullen.
Thank you.
Your Honor, we do respectfully request this be set for preliminary examination.
Discovery is complete.
To my knowledge, yes, Your Honor.
Yeah. People have their witnesses available the 23rd.
We'll do our best.
Preliminary examination in person, September 23rd, 2025, 9 a.m. before Judge Bar. Bond continue.
Thank you, Your Honor.
Thank you, Your Honor.
Court calls the case of the people versus Alexis Naveen.
Ashley calls for the people.
Oh, there she is.
Public Defender Natalie Pate standing in for Ms. Lauren Perny on behalf of Ms. Naveen, who is present via Zoom. Ma'am, can you please state your name for the court?
Alexis Naveen.
Thank you, Your Honor. I'm respectfully requesting an adjournment. The court should be in receipt of a green sheet. It is my understanding that we are requesting an adjournment to track progress in Veterans Treatment Court.
Yeah.
And Ms. Perny does need to speak to Ms. Naveen regarding an updated offer is my understanding, but I believe Ms. Phelps could probably correct me if any of that's incorrect.
Ms. Naveen, how you doing?
I'm doing quite well, Your Honor.
All right, good. All right, that's all correct.
It is, I had the opportunity to speak with Ms. Burton Harris, I'm sorry, Chief Assistant Burton Harris this morning, and there's some other things that are sort of working in the background. Ms. Perry and I were also able to chat this morning, but I understand that we're going to need an adjournment now.
All right. You want to go to the October date or you want?
I believe October would be sufficient, Your Honor.
Better, okay. So I'll adjourn this to October 9th, 2025, 9 a.m. or as your invite indicates, bond will continue. All right, thank you.
Thank you, Your Honor.
Take care, Ms. Naveen.
Thank you.
Court calls case People versus Nicola Nelson.
Good afternoon, Your Honor. Reagan for the people.
And Assistant Public Defender Ben Denowith on behalf of Mr. Nelson. I don't believe he's present, Your Honor. And he contacted our office this morning. He asked to
He's
appear. Is he on Zoom?
Sure. You can't see him because his camera's not on. Nicola Nelson. Is there off past that?
Thank you.
See if he pops in. Court does call the case of the People versus Cameron Nichols.
Ashley Feltus for the people.
Stephanie Cannon on behalf of Mr. Nichols, who is standing to my right. Mr. Nichols, could you please state your name for the record?
Cameron Nichols.
Thank you.
Your Honor, I believe this is our first PCC. We're asking for an adjournment to see what we can work out here.
Probable cause conference, September 30th, 2025, 9 a.m. That's a Tuesday. Bound continued. Thank you. Court does call the case of the People versus Dimas Paz Madrid.
Alexander, on behalf of the people.
Assistant Public Defender Alexis Zerb speaking on behalf, Mr. Paez Madrid, be present via Zoom.
Sir, can you state your name?
Dimas Paez.
All right.
Your Honor, we are requesting an adjournment to try to seek a global resolution amongst all of Mr. Paez Madrid's matters.
September 30th, 2025, 9 a.m. Bound continued.
Thank you, Your Honor.
Court does call the case of People versus Antonio Parker. You're all set, sir.
Alexander.
Set. Did he? I don't know.
Well, I believe I was trying to request permit to go back to Indiana to my home.
Go where?
Your Honor, that's my fault.
Hang on.
I'll finish this.
Your Honor, my apologies, and Mr. Paez, my apologies as well. He did want me to request if he could have permission to leave the state of Michigan. He's originally from Indiana. His fiance and 2-year-old son reside in Indiana, and he's already spoke with community corrections that if he were to get that permission to live in Indiana, that they would be helpful in setting up his testing in Indiana, and then obviously sign that release to get the test results sent over to community corrections.
Your Honor, I would object. I believe he can be extradited from Indiana for these cases here.
Was he extradited?
Your Honor, I'm not sure of that fact.
Yeah, I did. I had an extradition from Indiana. I was brought here. I was released on bond, and right now I'm asking for permission to go back to my home to keep
For
working.
extradited to the state. If you extradite to the state, I'm not going to give you permission to leave.
And Your Honor, my notes, an extradition waiver was signed by our office. I do believe he was extradited from Indiana for these cases.
For these cases, he was extradited from Indiana for these cases. Motion to travel is denied.
But
thank you.
Well, sir, you can keep with those faces. I don't think you want to do that. I've made my ruling. Turn your camera on. I gave my ruling. I gave the basis for that. If you've got a problem with that, the next hearing, and get those files in, will be in person. He needs to appear here. And then we'll see what faces you make.
No, I was not trying to make any faces. I was just like sad about it because I'm.
Court calls the
totally
case,
right.
People versus, shut him off. Court calls the case, People versus Antonio Parker.
And then on behalf of the people, Your Honor.
This is the public defender, Ben Denowith, on behalf of Mr. Parker, who is approaching the podium now. Mr. Parker, would you please state your name for the record?
Antonio Parker.
Thank you.
And Your Honor, we are asking for an exam date.
Discovery is complete. Discovery is complete.
Yes, discovery is complete.
People have their witnesses available the 23rd. Preliminary examination, September 23rd, 2025, 9 a.m. That's before Judge Fleischer.
Right here in the 23rd.
Bond continue.
Thank you.
It is. Small. Court calls the case of the People versus Glenn Pennington.
Mr. Public Defender, Ben Denowith, on behalf of Mr. Pennington, who joins me at the podium now. Mr. Pennington, would you state your name for the record, please?
Glenn Pennington.
I have a plea form. Is that what we're doing?
Yes, we have a no contest resolution.
I have a plea form that indicates that the defendant will be pleading to use of a controlled substance. He'll be pleading no contest to that in count 3. That's a 1-year offense. Upon a successful plea to that charge, count 1 and 2 would be dismissed. That's the court's full understanding of the agreement.
Defense agrees.
7 sworn.
Raise your right hand. Do you solemnly swear to affirm the testimony about to give will be the truth, the whole truth, and nothing but the truth? Yeah.
Yes, sir.
State your name.
Glenn Pennington.
Sir, it is this court's understanding that you are going to be pleading no contest to the charge of use of methamphetamine. Actually, that's what it's supposed to be.
Yes, sir.
Correct? All right. That is a misdemeanor punishable by up to 1 year incarceration and $2,000 fine plus court costs. You understand that?
Yes, sir.
Do you understand what a no contest plea is?
Yes.
All right, 2 things about it. I have to make sure that you understand it. First of all, it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, sir.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, sir.
You also understand that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Fleischer in the 14A4 District Court.
Yes, sir.
All right. Basis for the no contest plea?
Lack of memory.
And sir, to that charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
Yes.
Any questions regarding those rights?
No, sir.
Please look at paragraph 5 on the form. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
and of your own free will?
Yes.
Court has been provided Chelsea Police Report Milan Police Report for their case number 234341. Any objection to the court having reviewed that report?
No. Oh, sorry.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Sir, between the time I accept your plea and the time of your sentencing, if you commit misconduct as defined by the Michigan court rules, any sentence evaluation, the court would no longer be bound by any sentence evaluation or agreement. You understand that?
Yes.
And you also understand you could not withdraw your plea.
Yes.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
And have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of no contest to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14A4 probation. Sentencing in this matter will be
October 28th at 9 a.m.
October 28, 2025, 9 a.m. Bond will continue. Thank you.
Thank you, Your Honor.
Court does call the case of the people versus Dorinda, is it Krasinski?
Good afternoon, Your Honor.
Assistant Public Defender Hannah Apple appearing on behalf of Ms. Krasinski. Will you say your name for the record?
Need to unmute, ma'am.
Can you hear me now?
Yes, we can hear you.
Okay, thank you.
Your Honor, first, we are asking for an adjournment of the probable cause conference for plea negotiations. I received notice that there's still an outstanding bond violation for her failing to report for testing. She is in treatment at Grace Centers of Hope. She's reporting from there now as well. She's been testing there. I received an update. I had some issues getting in contact with her this past week, but I received an update from her case manager today with a slew of test results that are all negative. I provided those to community corrections and to opposing counsel. I have directed her, we reached out to her caseworker today that she needs to sign releases. But I believe based on all that she is compliant, she is in treatment. We just need to kind of tie up those loose ends regarding.
I have a warrant out for her currently, don't we?
Ms. Krasinski, do you have the information to call community corrections to sign over those release of information?
Yes, ma'am. I have community corrections, a phone number right here. Is that who I would contact, right?
Please call them immediately following this hearing, okay?
Okay, and yep,
There's a
absolutely.
Thank you.
Bond denied because of this. All right. As the prosecutor, have you had an opportunity to look through all of that?
I have not. It's about 50 something on pages and I just got it this morning, so I haven't had an opportunity to look.
Apple gave you like 50 pages, said, look at this now. That's what she
They look
did.
at
She,
it now.
no, she did say that, didn't she? And it was really demanding. Yes.
I'm so sorry. She appeared on 8/14. The bench warrant was canceled. It's a $10,000 PR bond. This is an updated violation.
Got it. Okay.
Yes, I've been in treatment since the 2nd of July.
No, that's okay. We've got that, so I don't need to
Oh,
deal with
exactly.
her. All right. Much time are you looking for?
If we could have a few weeks, I'm hoping based on, get some information and try to work out a plea
September
negotiation.
30th or October 9th?
October 9th.
And even
Thank you.
counsel, she took the
Thank
later.
you, Your Honor.
Thank you. October 9th, 2025, 9 a.m. Where your invite indicates bond will continue. Thank you.
Thank you.
Court calls the case of the people versus John Riggs.
Brian Bowling on behalf of Mr. Riggs.
Okay.
Mr. Riggs, can you state your name for the record, please?
John Riggs.
Thank you.
Your Honor, I'm asking for an adjournment to allow him to continue to work with our mitigation department.
Just wanna, your signature.
September 30th. 2025, 9 a.m. Bound continue.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, sir. Court calls the case of the people versus Kevin Riggs.
Good afternoon, Your Honor. Raymond Cook for the people.
Assistant Public Defender Alexis Zerbs with and on behalf of Mr. Riggs, who should be present via Zoom. Mr. Riggs, can you please turn on your camera, unmute and state your name for the record?
Kevin Riggs. This is Simpson.
Your Honor, we are requesting an adjournment. The people indicated that there was a newly authorized matter against him. That's not set for arraignment until November. So we were going to ask for about 4 weeks.
Excuse me?
The arraignment's not set until November. We were going to ask for about 3 to 4 weeks to see if we can get that pushed up so that we can work out these cases together.
It's a misdemeanor arraignment pretrial before Judge Fleischer. I believe November 10th is the date that I saw on on my court.
You get, I don't know if you're gonna get that pushed up, but that arraignment isn't until that date.
That's my understanding, Your Honor.
Crazy world. I'll just adjourn this to November 13th. 9 a.m. bound continue.
Thank you, Your Honor.
Thank you, Your Honor. Thank you, sir. Court calls the case People versus Jaleesa Robinson.
Assistant Public Defender Davy Lee on behalf of Ms. Robinson. Ms. Robinson, are you present?
Whoa. He's right here.
Oh.
Why are you yelling over there? He's right here on my screen.
Excellent, Your Honor.
Ms. Robinson, can you state your name, please, for me?
Jaleesa Robinson.
See, I told you, she's right there.
I'm very glad to see that, Your Honor. I do have a green sheet. We're requesting an adjournment as I have not been able to have contact with Ms. Robinson, who I would ask to please contact the Public Defender's office as soon as possible.
All right, I'll adjourn it to September 30th, 2025, 9 a.m. Ma'am, do you have the Public Defender's office number?
No, sir.
All right. You ready?
Just 1 second.
You're not driving, are you?
No, sir, I'm parked.
Okay.
Sorry. Okay, I have a pen.
You got it? Okay, it's area code 734 222 6970.
Okay, thank you.
Call them and make sure they have a good phone number and email address for you, okay?
Yes, sir.
All right, bond continued. Thank you.
Thank you, Your Honor.
Court calls case of the People versus Jesse Rogers.
Brian Bolling on behalf of Ms. Rogers, who's standing to my right. State your name on the record, please.
Jesse Rogers.
Your Honor, I'm asking for an adjournment based on my discussion with Ms. Rogers earlier this week. She has some paperwork that my office needs to review, so we'd like the opportunity to be able to do that.
Probable cause will be adjourned to September 30th, 2025, 9 a.m.
Thanks, Judge.
Thank
Thank
you.
you. Okay. No. Court calls case People, Jody Ann Russell.
Good afternoon, Your Honor.
Assistant Public Defender Alexis Zerps with and on behalf of Ms. Russell. Ms. Russell, can you please state your name for the record? Jody Ann Russell. Your Honor, we're respectfully requesting this be set for preliminary examination.
All discovery is complete.
To my knowledge, yes, Your Honor.
People have their witnesses available the 23rd.
Yes, Your Honor.
Preliminary examination in person, September 23rd, 2025, 9 a.m. That's before Judge
Barr.
Judge Barr. Bond continued.
Thank you, Your Honor.
Court calls case People versus Darren Sardiga.
Good afternoon, Your Honor.
Maybe.
Assistant Public Defender Chelsea Vergils with and on behalf of Darren Sardiga. Mr. Sardiga, please state your name.
Darren Sardiga.
Requesting an adjournment.
To continue our plea discussion.
Probable cause conference, September 25th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court calls case of the People versus Jeremy Schultz.
And Assistant Public Defender Natalie Pate, standing in for Public Defender Lauren Perny on behalf of Mr. Schultz, who stands to my right. Please state your name, sir.
Jeremy Schultz. Okay.
Thank you, Your Honor. As to the PCC, I'm respectfully requesting for an adjournment. Ms. Perny advises that we seem to be missing some discovery, a photo lineup, and we do not have that photo array. So we'd be asking for an adjournment.
I have a violation report. Has he gone over to community corrections at all?
I can address that, Your Honor. So
Yes.
it's my understanding that he was released from Washtenaw County Jail and then transferred directly to Wayne County Jail, where he was then incarcerated for 2 months. Lauren Perny advises that she did speak with his probation officer in Wayne County via telephone to confirm this, and did send her written confirmation, which I do not have right now today, that Mr. Schultz is testing with them on probation also, and that he last tested on August 18th and it came back negative, and he is attending AA. He states to me that he is willing to test today, asking for the court to allow him to go test and that he would come back clean. He just advises that when he was transferred to Wayne County, he was not told that he needed to re-enroll with community corrections.
Well, he needs to go over and re-enroll and test at community corrections. No problem. We'll need a new order. And I'll adjourn the probable cause. That's what you're requesting.
Sorry, Your Honor.
I'll adjourn this to the 25th of 2025, 9 a.m.
Thank you, Your Honor.
Ron, I have to come back. We'll be preparing a new order. He needs to go over there now.
Thank you, Your Honor. And my client is asking if he should return to court after he tests today.
No, you're dirty. Just to have your affairs in order. We're up on the 25th.
I have to do a hair today for a job interview, so I'm not worried.
Thank you.
Thank you, Your Honor. He'll head
Thank
over
you.
there right now. Thank you.
I only get 2 days.
Yes, you did.
Thank you so much.
Court does call the case People versus Diana Seaborn.
That's Schultz with people, just the one.
Yeah.
And Public Defender Ben Dunaway on behalf of Ms. Seabrook, who stands to my right. Would you state your name for the record, please?
Diana Seaborn.
All right.
Your Honor, we would like an exam date, please.
Discovery is complete.
Yes, Your Honor.
People have their witnesses available the 23rd.
I'm just checking, I'm just getting in, so just double check real quick. We'll try for that day, thank you.
Preliminary examination.